I reckon. My lord, may I be permitted to mention an application, a civil revisional application for inclusion, my lord. My lord, may I be permitted to mention a contested civil revision, lordship, for inclusion. Lordship, my learned friend is also there. Lordship, I do not know.
Before Justice.
Lordship, my Lord Justice Hiranmoy Bhattacharya had expressed.
Lordship is
Lordship,
hearing out the matter.
Lordship, the Honorable Justice Hiranmoy Bhattacharya expressed that because the business is not permitting him to take it up, he has asked me to.
Business won't permit this bench also for the coming fortnight.
I don't know.
This bench will be circuit.
Lordship, may it be included.
My lord, this matter was heard at length.
Lordship, they
My
are not
lord.
allowing me to.
This
Is involved in the arbitration proceeding.
Coming fortnight, this bench won't
No,
be
this has got nothing to do with the arbitration proceedings, my lord.
Lordship,
It
the
has got
order has
nothing
been
to do with
passed
the
by the
arbitration
tribunal, Lordship.
any mention.
No, it has not stayed.
To mention a matter for inclusion, my lord.
May I permitted to mention?
Again, na. Age mention korte din. First.
Lordship, may it be included, may it be taken
My
up.
lord, it has been heard by Justice Bhattacharya.
Whom to hear? You or him? Whom to hear? Let him get the first. Please.
May I be permitted to mention a matter for inclusion, my lord?
What?
Revision,
Revision.
Revision, my lord.
Contested?
No, no contested. May I?
May I permitted to mention? May one civil.
Let the senior mention. What? Inclusion of?
Hearing. Civil revision.
Civil revision.
My lord, in these two, my lord, I intimation served to my learned friend who is sitting in my forest. I intimated her.
Is there any endorsement to that effect?
No endorsement. I want she
Let
assured me I
no,
will come on.
Learned counsel. Let there be some endorsement.
Then I am getting endorsement. I give it at two.
In respect of these two matters. In respect of these two matters.
No, this is
the separate one.
Communication.
Achha.
Intimation, communication,
Intimated.
accepted, and these
Endorsed.
two matter, my lord, I intimated.
Let it be endorsed.
I get it endorsed and file it at 2. If your lordship.
Yes. Tomorrow at 2 p.m. Tomorrow at 2 p.m.
May I have your lordship's kindly to mention? My lord, I had mentioned this matter, my lord, before. This is, my lord, arising out of an application, my lord, where, my lord, the Section 8 application was, my lord, allowed, but despite thereof, the suit was dismissed. It is a contested application, revisional application, my lord. If your lordship, my lord, kindly takes it up, the urgency is that, my lord, now, my lord,
When?
My lord, any day convenient. I know, my lord, lordship is going for the circuit. I know, my lord, your lordship had indicated your lordship is going for circuit.
Tried before any other benches. There are several.
I want to come before your lordship.
No. Try it within this fortnight, coming fortnight. If it is not possible, then.
My lord, I'll tell your lordship very frankly.
No.
My lord, may I permitted to mention one matter?
I'll tell you, lordship, urgency, this bench won't accept at this juncture.
Very well, my lord, very well. I'll tell your lordship, my lord, one thing. The suit has been dismissed.
Learned counsel.
Yes.
Prefer it before other benches. If it is not possible within fortnight, then you come.
Because it is a contested application.
Learned counsel, please. Next.
My lord, may I permitted to mention one matter? This is a civil revisional application for inclusion in the list. Only for hearing and as per your convenience. Any.
Permit to mention item number 50 of my lord's today's list. It was being inadvertently listed under the heading hearing. As per my lord's last order, item number 50. 50. It was supposed to be listed as under the heading application. As per my lord's last order.
It will be coming under the heading application.
Yes, my lord. It was listed under the heading.
দেখে নেবেন পরে দেখে নেবেন যদি আজকে না হয় যদি আমরা না পৌঁছই তাহলে দেখে নেবেন ওটা অ্যাপ্লিকেশনে দেবেন ঠিক আছে লাস্ট অর্ডার দেখে নেবেন यस
ডিপলি প্লিজ মাই লর্ড
আইটেম নাম্বার 50 ওটা 50 নিন that one, the WBACDC.
My lord has given me a very short time.
I wanted to, I missed out on one point. I indicated your lordship said on next day. Just one point I missed out.
Which point?
That point is that regarding the delayed payment surcharge, my last point is that it is a new claim on the basis of new cause of action. I'll just refer to one judgment But before that, kindly come to
Item
page
number
50 for a
eleven.
moment. Just 1 second. Page 50 of the petition. The chart is given. Your
Yes.
lordship had pointed out the last bill was June 2014.
Minute.
June 2014, your lordship find the last bill. Your lordship had
June.
pointed out. Now the suit has been filed in September, so they could have filed. They chose not to. Not due diligence. The main point is kindly come to the bottom. Further delay, then at page further delay payment surcharges to be calculated after payment of the entire dues as per WB ERC, West Bengal Electricity Regulation Council rules. This rules is for the first time pleaded here, not in the plaint. So this cause of action is on the basis of he himself mentions WBERC rule.
What is this petition?
This is amendment petition.
Order 617.
Yes. For the first time, my point is this is a new cause of action and new claim. And on that, and this cannot be allowed, and especially and also because it is not only a new claim but barred by limitation. On that, I am relying on the latest Supreme Court judgment. This last judgment, 2012-16 SCC. May I hand over my?
I'm only relying this judgment only.
Just indicate the paragraphs.
Better for you also.
Yes.
Because I have only one judgment, that is this judgment.
Para
I'm relying.
22.
1 minute.
Page 15, my lord, para 22.
1 minute, Lord Counsel.
তার এইটুকুই দরকার নেই তো আপনি চালান তাহলে আমি পরের দিন এখন
Paragraph
22.
22.
Page 15, para 22. Just this para I'll place, my lord. Trouble your lordship.
Yes, paragraph 22.
Yes, it would be refers to an old decision of Supreme Court AIR 1957. Old is gold, my lord. It would be useful to also notice the observations of this court in Pigonda Hongkonda Patil versus Kalgonda Shidgonda Patil, wherein this court considered an objection to the amendment on the ground that the same amount to a new case and a new cause of action. In this case, this court laid down the principles which would govern the exercise of discretion as to whether the court ought to permit an amendment of the pleadings or not. This court approved the observation in this judgment when he laid down the principles. Then the principle. All amendment ought to be allowed which satisfies the two conditions. A, of not working injustice to the other side. B, of being necessary for the purpose of determining the real questions in controversy between the parties. But I refrain from citing further authorities as, in my opinion, they all lay down precisely the same doctrine. That doctrine, as I understand, is very important, is that amendment should be refused only where the other party cannot be placed in the same position as if the pleading had been originally correct. But the amendment would cause him an injury which could not be compensated in costs. It is merely a particular case of this doctrine, a species. One example is particular case of this general rule that where a plaintiff seeks to amend, I'm relying on this, amend by setting up a fresh claim, is delayed payment surcharge. This was never there. In respect of a cause of action on the basis of WPARC rules pleaded for the first time in the amendment application, which since the institution of the suit had become barred by limitation, the amendment must be refused. I'm relying on this.
You are relying upon, it is merely a particular case of this general rule that where a plaintiff seeks to amend by setting up a fresh claim
Yes,
in respect of a cause of action which since the institution of the suit had become barred by limitation,
yes, the cause
the
of action.
amendment must be refused.
Yes. So this is a cause of action on the basis of WBAC rules, DPSC, which was never raised. I couldn't deal with it. It's never raised in the play. For the first time when it is raised in 2019, the new claim of delayed payment surcharge on the basis of this rule, this cause of action, is barred by limitation.
Yes, sir.
There are
You will also get the opportunity. Learn
yes.
also.
There are two other paragraphs, the concluding portion, just two paragraphs. Kindly come to the penultimate page. Page 35.
You are relying upon 71.
Yes, I'm
71.
71. I'll be very precise. 71 V2 3.
3, 2. So to avoid multiplicity of proceedings.
Yes, I'm obliged. Avoid multiplicity of proceedings.
Provided
Amendment, the part C, the amendment does not raise a time barred claim resulting in divesting of the other side of a valuable accrued right. The same thing. Ultimately, in conclusion, it.
yes.
Then 71, one paragraph below, 71.4.1.
Yes.
Yes, 70. By the amendment, a time barred claim is sought to be introduced, in which case the fact that the claim would be time barred becomes a relevant factor for consideration. So that should be taken into consideration. Normally it is liberal, but
according to you, if it is time barred,
yes,
there should not be amendment.
My basic points is first is that order 6 rule 17 proviso. My 4 points, or for proviso, which says that an explanation has to be there if hearing has commenced, issues have been framed, hearing has commenced, then he has to give an explanation why he was precluded, couldn't raise the issue when the suit was filed. That is number one. Number two is that normally time barred claim should not be allowed, both the claims which he has raised. One is addition of claim under the bills, which is not explained. And the second is delayed payment surcharge. The third point is the learned judge himself found that the plaintiff has not been there has been no due diligence on part of the plaintiff. After coming to that finding, the learned judge could not have allowed. I have relied upon, on that point, I have relied upon a Supreme Court judgment. Due diligence. And the last point is a new claim cannot be added if it is time barred. And one thing, the judgment which I have already cited, AIR 2009 Supreme Court. When
This one.
2009 Supreme Court
earlier.
I already cited. I have inadvertence. I missed to point out para 8 also. I am relying where the court held that
one minute, counsel.
AIR
You have cited 2018.
Before that,
2008 14 SCC 632.
yes.
And you have cited 2020 volume 11 SCC 549 and 2009
Yes,
Supreme Court 1433.
One paragraph I omitted. Just I'm pointing out the paragraph 8.
You had relied upon 11.
11, but I am also relying upon paragraph 8, where the Supreme Court says that hearing commences with the framing of issues. So in this case,
sir.
issues were framed, hearing was commenced. So order 6 rule 17 provides that applies. An explanation has to be given why he couldn't include those claims at the time of filing the suit, which explanation is not there. These are my points. Obliged.
And you are heavily relying upon the claim being time barred. It ought not to be allowed. Amendment
All these points, including this time. I'm deeply obliged for a patient here.
One minute.
Yes.
Yes.
Lord, I shall start the last point taken by my largest friend student.
Time bar.
Time bar. Before that, your lordships kindly consider it's a claim of interest. Late payment surcharge means interest. You have not paid the amount of the bill in stipulated period, you are to pay interest. Nothing else. Only interest. For delayed payment. Everywhere, your lordship knows, interest is there.
Yes.
That is established. Now, your lordships kindly come to, and on that date, the suit, my largest friend is annexed, is a hazy. It's very difficult to read out. Your lordships, on last occasions,
If it had been,
last occasions, your lordships, one queries was there whether this interest past was mentioned in the plaint or not. On last occasion,
yes, can this original plaint be?
yes. Kindly come to page 40.
Photocopy of the,
I shall, I'm sorry, it is not.
can it be provided today itself during the course of this day?
I'll just check.
It's a really very,
Otherwise, tomorrow.
No,
we-
I'll
we can
try
do
to give it by.
kindly, come to page 42.
42,
42.
yes.
It's a very difficult for me to read out. However, I shall try. Paragraph 7. It is also appears that defendant company did not avail the opportunity of repayment such and such request, such and such. Well, it's very difficult. Or liability to pay the said quantum of bill amounting to rupees 7 crores 25,088 and odds, along with accrued bank interest. Now, my lord, prayer. But even if kindly come to prayer. Page 44. C. A further accrued bank interest from 31st March 13 to till realization. Even if amendment is not allowed, I am entitled to realize the payment with interest. That is late payment surcharge. That is late payment surcharge. So that was there in the plaint. Your lordship's queries was there that I think, my lord, I have satisfied. Now, my lord, next point is, my lord,
Yes. Next point.
this late payment surcharge, that is interest, when this will accrue, that has to be taken into consideration. My learned friend says, this is a new, this is a fresh, therefore it is time, but no. The concept of LPSC comes after making payment, because so long it is dues, LPSC will accrue. That regulation is there. Percentage mentioned in the regulation framed by the Regulatory Commission. For 3 months, one, for 6 months, one. After lapse of 6 months, one. There is a percentage, the regulation is there. So, till now, so long the dues continuing, LPSC will accrue. Even today also LPSC will accrue. No one in a position to calculate the LPSC unless it is completely paid. That's
According to you, it will be assessed taking into consideration when it ought to have been paid and when it has been paid. This interregnum period is to be taken into consideration while calculating the late payment surcharge.
even after completion of the suit degree, after payment, LPSC will accrue. Therefore, order to rule 2 will not applicable so far the electricity dues is concerned. This is not a new cause of action or fresh. Before coming into judgment, my lord, all this. First of all, I shall have to clear to your lordship the factual aspect. So today also LPSC will accrue. That's the concept of LPSC. LPSC means interest. এই ইলেকট্রিসিটি অ্যাক্ট তো আপনাদের কাছে নেই, আছে? দেখুন তো।
নাহলে আনিয়ে নিন, বুঝেছেন? না থাকলে আনিয়ে নিন।
My lord, so far, this is a electricity dues. My lord and friends heavily relied upon this is a bar, this is a bar, we cannot raise. Kindly, my lord, this is one copy, I will supply to your lords after it. Section 56, subsection 2 of Electricity Act 2003. Three. Electricity Act 2003. Notwithstanding anything contained in any other law for the time being in force, no sum due from any consumer under this section shall be recoverable after the period of 2 years from the date when such sum become first due. That is one. Unless first due, I will explain what is the first due. Even today also first due, because LPSC will accrue today also. So long my largest friends not deposit the entire amount, interest will accrue. The first due, if today we will calculate the LPSC, it becomes a first due from today. Thereafter, unless, that point is not required for last paragraph, unless such sum has been shown continuously as recoverable of area charges for electricity supplied, and the licensee shall not cut off the supply of the electricity. Unless it is shown continuously shown as recoverable. Today also it is continually shown as recoverable.
Until and, according to you, until and unless it is paid, it cannot be calculated.
That is the law, not me. It's right from Supreme Court statutory provisions. This is established law. My largest one knows very well. Kindly see the 56. 56 subsection 2. Unless it is continuously shown as recoverable, it is barred. But the moment it is continuously shown as recoverable, the question of bar limitation does not arise. For this point, at least, my lord, thousands of judgments are there. I am not traveling to your lordship. This is established. Sir, it is continuing. Therefore, question of bar does not arise. So long he paid, this is continuing. So, my lord, interest part is there in the plaint. The question of bar does not arise. The calculation at the time of filing suit, it is impossible to calculate LPSC because unless the dues paid, calculation will accrue. So therefore, there is no question of limitations. The factual aspect, I think, my lord, I clear to your lordship. Because today also, LPSC will accrue.
Now you're relying upon
This judgment,
2216.
yes, 20 to 16 Supreme Court cases.
Which paragraph?
My lord, I am coming. First of all, your lordships kindly see page 3, D. What is the factual matrix of the case? At the time, my lord got it.
1 minute.
This 22 judgment Milos covers right from Privy Council till Supreme Court. All those all judgment delivered has been distinguished. So therefore, this is the only judge.
Upon paragraph.
My lord, I am coming. Paragraph. I am coming. Prior to that, your lordships kindly come to page 3 of the judgment.
Page 3.
Page 3, 4. What is the factual aspect of the, what is the case? At the time when the suit comes to the institute, the damages to the tune of rupees 1 crores and odd in the alternative was paid for by way of amendment. The damages now paid for is to the tune of rupees 4 crores and odds. So dispute is initially when the suit was filed, it was 1 crores and odd. Now subsequently, by way of amendment, sought to enhance 4 crores and odd. That is the subject matter of the matter. The matter was, amendment was allowed. It was challenged before the single bench of Bombay High Court. High Court, my lord, allow, upheld the judgment of the lower court, file appeal before the division bench dismissed. Against that Supreme Court. Against that, this Supreme. Now my learned friends, my lord, relied upon paragraph 22. I am coming. Factual aspect, my lord. Now paragraph 8 onwards, your lordships kindly see. But forget about this is the submission, I will not require. Analysis. Paragraph 18, 17, 18. Page 14, paragraph 7.
Yes.
Analysis. Before adverting to rival contentions canvassed on either side, and before we deal with the order passed by the High Court permitting the plaintiffs to amend the plaint with respect to prayer laws, let us consider the laws on the question of allowing or rejecting the prayer of amendment of pleading, more particularly when the plea of limitation was taken by one of the parties. It was well settled that the court must extremely liberal in granting the prayer for amendment. If the court is of the view that if such amendment is not allowed, a party who was paid for such an amendment shall suffer irreparable loss and injury, it is also equally well settled that there is no absolute rule that in every cases where a relief is barred because of limitations, amendment should not be allowed. It is always open to the court to allow an amendment if it is of the view that allowing an amendment shall really subserve an ultimate cause of justice and avoid any further litigations. Well, let's suppose this amendment was not allowed. What will happen? We will file another case for realization of LPSC. It's a statutory dues. So Supreme Court says, very conscious, that to avoid further litigations. Now, my learned friends' contention, it is a fresh cause of action. That I think, my lord, I will clear to your lordship, because this is not a fresh or new cause of action. This cause of action will continue till filing the suit, even till today. Now, my lord, paragraph 21. So far as the answer to the specific plea that the claim of damages is barred by limitation and cannot be permitted at this stage is concerned, it becomes necessary to examine the various judicial pronouncements of this court the principles governing an amendment which may be permitted even after the expiry of statutory period of limitations. Here, my lord, after 35 years, amendment was allowed. Here in the instant case, the statutory period of limitations were laid down by the Privy Council in its judgment in Charandas versus Amir Khan. In this case, the Privy Council laid down the principles thus, SCC online such and such, that there was full power to make the amendment cannot be disputed, and though such a prayer should not as a rule be exercised where its effect is to take away from defendant's legal rights. Here, my lord, the question of take away of defendant's legal rights does not arise, which was accrued to him by lapse of time. Yet there are cases. See, for example, Mahat Jamadar Anil such and such, where such considerations are outweighed by the special circumstances of the case, and their lordships are not prepared to differ from the Judicial Commission in thinking that the present case is one. Now, my learned friends relied upon paragraph 21. 22. Now, my lord, I am coming 22. It would be useful to also notice to observations that this court, such and such, wherein this court consider an objection to the amendment on the ground that the same amount to a new case and a new cause of action. My respectful submission, my lord, this is not at all a new cause of action. The cause of action will continue from even prior to file suit and till date also. Because LPS is an interest, it is accrued day by day. So therefore, question of new cause of action does not arise. In this case, this court laid down the principles which would govern the exercise of discretion as to whether the court ought to permit an amendment of this pleading or not. This court approved the observations of Bachelors versus such and such, where when he laid down the principles thus, all amendment ought to be allowed which satisfy the two conditions. One is no working justice, not working, it is working justice to the other side. Second is necessary for the purpose of determination of real question of controversy. So, my lord, here satisfies the real question of controversy. And my learned space defense is not struck out by allowing this amendment. He can file an objection. He can take limitation point also before the suit. There is no difficulties. Now, my lord, the last paragraph, it is merely a particular case of the general rule that where the plaintiffs, my lord, right from 1, 2, 3, 4, 5, 6 lines after.
Yes. It is merely.
Yes, it is merely a particular case of this general rule that where a plaintiff seeks to amend by setting up a fresh claim in respect of cause of action, which since the institution of the suit had become barred of limitation. So therefore, here in the instant case, the question of since the institution of suit became barred does not arise because of interest. Your lordship knows if I take loan from the bank, so long I am not paying, my lord, interest will accrue till date. That's the same analogy. So therefore, my learned say relied upon this paragraph. In my respectful submission, this is not help my learned friends. Now, my lord, paragraph 23. And the last portion of that paragraph, the ultimate test, therefore, still remains the same. Can the amendment be allowed without justice to the other side, or can it not? Next paragraph. Thus, this court has repeatedly held that the power to allow an amendment is undoubtedly wide and may be appropriately exercised at any stage in the interest of justice, notwithstanding the law of limitation. In this behalf, in such and such paragraph. Now, my lord, next paragraph. The power to allow an amendment is undoubtedly wide and may at any stage be appropriately exercised in the interest of justice. The Supreme Court is of the opinion, even after completion of evidence also, if it is really that the learned court think that it is really needed for the proper adjudication of the interest of justice, that can be, amendment can be allowed. appropriately exercised in the interest of justice for law of limitation, notwithstanding, but the exercise of such reaching discretionary power is governed by judicial consideration, and wise discretion greater ought to be the care and circumstances part of this court. Now, my lord, paragraph 25. The principles applicable to the amendment of the plaint are equally applicable to the amendment of the written statements. That's important. The court are more generous in allowing the amendment of the written statement as question of prejudice to less likely to operate in that event. The defendant has a right to take alternative plea in defense, which, however, is subject to an exception that by the proposed amendment, other side should not be subject to injustice. Here, question of injustice does not arise. And that any admission made in favor of the plaintiff is not withdrawn. All amendments of the pleading should be allowed which are necessary for determination of the real controversies in the suit, provided the proposed amendment does not alter or substitute a new cause of action on the basis of which the original it was raised or defense taken. So therefore, that question does not arise. Inconsistent and contradictory allegations in negation to the admitted position of the facts or mutually destructive allegations of facts should not be allowed to be incorporated by means of amendment to the pleadings. The proposed amendment should not be cause such prejudice to the other side which cannot be compensated by cost. No amendment should be allowed which amounts to or relates to the defeating or legal rights accruing to the opposite party on account of lapse of times. Well, I am reading because this is a case of my learned friend Srilite. So, my lord, here, my lord, the defense of my learned friend struck out, question of does not arise. Now, question, my lord, the delay in filing of applications for amendment of pleading should be properly compensated by cost. An error or mistake which, if not fraudulent, here, my lord, the question of fraud does not arise. It's a government revenue. Should not be made a ground for rejection the application for amendment of plaint or written statements. See,
Yes.
here, my lord, relied upon the judgment South Konkan Railway versus Prabhat Gajanan Naik. 26. But undoubtedly, every case of every applications for amendment has to be tested in the applicable facts and circumstances of the case, as the proposed amendment of the pleading amounts to only a different of an additional approach to the same fact. Kindly take a note. This court has repeatedly laid down the principle that such an amendment would be allowed even after the expiry of statutory period of limitations. This is a different or an additional approach of the same facts. It is really an additional approach of the same facts. Plain it was mentioned interest. The calculation just by filing an amendment, calculation even after this amendment also will not another LPSC will be accrued. Because unless completely now, no,
Paragraphs are there.
no, this judgment, so many paragraphs. So many.
No. Which paragraphs are you referring?
Paragraph 27, 28,
27,
28,
28.
29, 30. Here latches also deal. Paragraph 30.
No. Which are relevant?
Yes,
Which
30.
are relevant?
Yes. 30, 31, 32, 33, 34. 36. And 37 last portions. The defendant can always file an additional written statements to contest the claim of the plaintiffs. Now, my lord, the last portions, paragraph 65, 67, where, my lord, order 6, rule 17 and my lord 71 also. My learned friend says, my lord, only C, amendment does not raise a time barred claim. Here question of time barred does not arise. Therefore, I am relying upon 71, 71.1, 71.2, 71.3, all these paragraphs. The question of time barred does not arise. And last portion, my lord, 71.11. And 72, 73. The Supreme Court also allow the amendment of enhancement. If your lordship so, I can read it. So, my lord, sum and substance, it's an interest. LPSC is a statutory dues. It is established law. We can charge LPSC after making full payment of the billed amount. Therefore, question of time barred, question of limitation does not arise. And further, my lord, the laches, due diligence, with due respect to the learned lower court, my lord, it says it is not at all a laches on our part. Because today also LPSC will accrue. And your lordship knows very well, even without my lord legal provisions. If my electricity bill I will not pay, after 3 months they will disconnect and raise my lord additional bill. So interest is there, it's a statutory provisions as per regulations. So my respectful submission, my lords, kindly allow this amendment, because the Supreme Court considered this judgment all right from Privy Council till and ultimately allowed. It's a statutory dues.
I will just respond to these two paragraphs.
Which
my
line?
learned friend-
Are
These
he
two,
respond?
these two paragraphs, just which is referred. Just two things
For your satisfaction, yes.
for my satisfaction. Yes. Number one is that there are two claims.
Hmm.
So far as the first claim, it is barred by limitation, there is no continuous cause of action. So far as the second claim of interest, my understanding is that even if interest accrues, I am assuming what my learned friend has said is correct. Kindly see that in 2014, the last bill I have not paid,
Hmm.
on that interest is accruing.
Hmm.
That interest after 3 years become time barred.
Hmm.
Today's interest may not be time barred, but 2014 up to suppose the interest on March 2014 will be time barred when the 2019 amendment is brought.
কোথায় time bar
2019.
পাচ্ছেন স্যার?
Just a second.
Electricity Act 56.
So the entire claimant, part of it will definitely be time barred. And that is what my learned friend is trying to include. Now these two paragraphs which my learned friend has relied on, 21 and 25, it kindly
Not
come to
20
the
or
judgment.
25. I'm relying
So many paragraphs, but
The entire
specifically
judgment.
25 to 21 and 25,
Hmm.
your lordship will see amendment should be liberally allowed.
Hmm.
I have no quarrels with that, but these two refers to judgments. 21 refers to a judgment. 6 is 21 Privy Council.
Hmm.
All judgments are prior to 2002, before the amendment of Order 6 Rule 17. Order 6 Rule 17, I'll just read the amendment proviso. Provided that no application for amendment, this is a mandatory provision in SB Sinha's judgment. No application for amendment shall be allowed after the trial has commenced, unless the court comes to the conclusion that in spite of due diligence, the party could not have raised the matter. Now, in this very case, the learned court below found that there has not been any due diligence.
Learned court allow করলো, the Supreme Court says there is no laches.
So in these two paragraphs, this provision, which is mandatory as per the 2009 Supreme Court, this aspect has not been considered by the learned trial court judge. If it's no due diligence, it has to be rejected. This is one of the additional points. Those are my submissions.
With interest plenty বলা আছে, চিন্তা করছেন কেন?
And the interest in the plaint is bank interest that is totally different from delayed payment surcharge. Bank interest is something else, and delayed payment surcharge under the Electricity Act is a separate thing.
Sir, bank interest অনেক বেশি 6%, 7%.
Those are my submissions, ma'am. I'm grateful for a patient hearing.
চলুন যাবেন এটা তো রিজার্ভ করবে
The learned counsel representing the opposite party and petitioner, heard learned counsels representing the petitioner and the opposite
WBSCDC.
party, that is WBSEDCL. WBSEDCL. Full stop. Apart from the earlier judgments referred on the earlier occasion, the learned counsel representing the petitioner has relied upon an authority passed by the Honorable Apex Court, published at 2022, volume 16, SCC, page 1.
I am also relying.
This self-same judgment has also been relied upon by the learned counsel representing the opposite party. Paragraph, hearing is concluded. Reserved for judgment.
Grateful to you.
Grateful, ma'am.
স্যার ইন্টারেস্ট দেবেন না মারপিট করবেন সরকারি নিউজ গভর্নমেন্ট রেভিনিউ দেবেন চলুন
But I asked the solicitor to give a copy of the plaint. I tried to get it.
Hand it over to the court officer. উনি একটা ফ্রেশ কপি দেবেন প্লেন্টের, সেটা এই যে এনভেলপে দিয়ে দেবেন, ঠিক আছে?
Whatever is available, I'll try to.
Item number 2.
But on behalf of the respondent, I'm in utmost difficulty today. The difficulty is I've been very, well, day before yesterday, I've been briefed. I'm not ready at all with the matter. If Lordship could kindly accommodate me for a fortnight, my lord, I will come totally ready to conclude the matter, my lord, once and for all. Mr. Anirban Kaur is there with me.
I will it be Mr. Surinath Mitra in this matter, Your Lordship?
But we are not ready, my lord.
We have
also
we have certain urgency in this matter as Mr. Mitra has submitted on the previous occasion before Lordship. On that day, Your Lordship has
no, Mr. Now I can recollect.
Yes.
Mr. Mitra was submitting that
notice.
there's no, as regards to urgency, he has not submitted.
No,
He has submitted that
piecemeal
a
submission.
hearing should take place, according to him, may be taken up on one day.
Yes.
When the hearing is taken up, let it be concluded by both the sides.
Yes, yes,
That was the submission.
yes, yes,
So
absolutely. I bow down.
let us have it
Yes,
after
please.
just after the reassembling of this bench, after the circuit bench.
Very good. As your lordship may direct.
So, which date?
Lordship has a
14th,
14th of September.
14th of September,
No problem.
14th of September. Whichever suits both of you, 14th or 15th or 16th,
Well,
whichever.
we come to court every day. Those dates are not important, my lord. Whatever suits your lordship, my lord.
Lordship, make it 15 because 14th is a Monday.
Yes.
Maybe Mr. Mitra has got PIL matters before the chief. 15th would be the
এটা একেবারে, the learned senior counsel representing the petition, representing the respondents.
Well, I'm not senior, my lord.
Acha. And
Shourodipta Banerjee.
The learned counsel representing the respondents seeks an accommodation. Seeks an accommodation for a fortnight. Full stop, paragraph. On consent of both sides, let the matter appear on 15th. আচ্ছা 15th এ একবার দেখুন তো 15th এ টপে কিছু আছে কিনা 15th এ 12টায় আছে তাই তো তাহলে 12টা কি ক্রিমিনাল অ্যাপিল
Second half will be.
Can it be on 16th এ দেখুন তো 16th এ
My lord, can it be at 2 p.m., my lord?
criminal appeal so
No, any day at 2 p.m., my
yes.
lord.
Any day, if your lordship can fix it at 12, subject to your lordship's diary.
ঠিক আছে।
Learned counsel, this being a criminal appeal,
Lordship,
it has been specially fixed at
Very
12.
any other day.
any other days, your lordship.
আচ্ছা দেখে নিন তো কোনটা মানে টপে কিছু নেই এমন কি আছে পরে যান তারপরের উইকে যান দেখি এই যে এই উইকটা 21st September 22nd September
14th.
টপে কিছু নেই
কেন?
21st Monday
14th, will it be there, lordship, as lordship preferred 14th?
Any day
14th
before
দেখো।
15th, if possible.
I don't think 14th will be convenient because after a fortnight I don't think so. The 21st or 22nd? 21st is Monday.
22nd.
22nd.
22nd of
Tuesday.
Some difficulty.
কবে চাস 21st 22nd ও থাকবে না? But he
Let it come from the bar.
তুই কবে থাকবি না রে 21-22 থাকবি না তাহলে কবে
Then
থাকবি?
your lordship, let it be on 15th, whatever be the number, we'll take our chance.
No, it is in the top one.
Very well, lordship.
15th, there's a 12 o'clock, there's a matter, lordship.
12 আছে এই তো 12 noon.
10:30 will come.
But 15th can it be at 2, my lord, if convenient?
15th কি 15th Tuesday no?
15 তারিখ দুটো সময়।
criminal appeal to I think criminal appeal will
Very well,
continue for মানে maybe for the entire day from 12 noon.
Whatever is convenient, man. 21st and 22nd, I'm told that Mr. Kaur will not be there.
Lordship, let it be on 15th at the top, we'll do it.
How much time? It
But we
cannot be. It will take some time.
Yes,
They
your
will
lordship.
first make their submissions and we need considerable time, my lord.
We'll also need some time. We won't be finishing in one day.
কিসের?
17th কি আছে 17th Thursday 17th মনে হয় কিছু টপে নেই তো Can it be on 17th at the top 17th?
Yes, your lordship.
But only
Thursday.
one thing, my lord, the court officers will determine whether all the documents are before your lordship or not.
So I think it will be better. It will be better if during the course of this day, let learned counsels who are the advocate on record
But
on
we
behalf
have
of both the
checked,
sides.
the documents are not there, my lord.
Just indication of documents which are there, there were documents marked as exhibits, those have not come.
Exhibits have not come before your lordship, my lord, in the
Lordship,
record.
let them prepare a supplementary, whatever documents if
We
they
can do
have.
that. But the exhibited documents before the learned trial court,
Subject to
trial court record টা বার করুন trial court record
but those have not been a part of the paper book.
trial court ওই record টা বার করুন
Special message.
TS
No, my lord, this is
This case.
miss case.
this one is miss case
Yes,
the trial court record
it was an eviction suit. Out of the eviction suit, there was a miscellaneous proceeding. My lord, the numbers,
you are referring to the ejectment suit
ejectment suit before.
No.
তাহলে? My lord,
the documents ought to have oh no you are referring to the miss case
Lordship,
Order
we had
9,
filed
order
an
9 something.
application under order 21 rule 97 to 101.
order 90 to
That was marked as a miss case. In the miss case, we had tendered documents which were marked as exhibit. Those
One minute,
documents have
one
not been
minute.
included.
what is the number of the miss case
Miss case is 198 of 2017.
একবার দেখে নিন তো
May I only indicate May I only indicate the Honorable Division Bench, while framing the issues by its order dated 5th of December 2024, had already directed the trial court records to be called for by special messenger. So it should be before your lordship, even if not a part of the paper.
The order also records that they have not come. Lordship will kindly take volume 3, the last page, page 394. Lordship will find that an order of the registrar.
Let us go through the record, whether it has come or not. ওই মিস কেসের নাম্বারটা দেখে নিন দেখুন
There is
আছে
an
কি-
order of the learned registrar.
registrar dated
Page 394 of the paperwork, 16th July 2025. But no information, not the TCR in connection with miss case number 198 of 17 has been received by the department as yet.
And there was a reminder sent, and your lordship is keeping on 17th.
তারপরে দেখুন তো তারপরে কোনো অর্ডার আছে কিনা রেজিস্ট্রারে It will be better during the course of this day,
My lord,
let the learned advocate on records
Lordship,
come and have
may I
a
indicate one more thing,
inspection.
the advocate on record, I have been made the advocate on record. The advocate on record is actually somebody else.
That is
কার নাম আছে? ওর নাম আছে?
Your Lordship, would kindly, Lordship, all the lower court record, there's an leave has been granted to us to take an inspection on the last date. Your Lordship, on the your Lordship's order reflects that a leave has been given to the advocate record. We have taken an inspection. All the lower court records are here before your Lordship. Your Lordship, kindly check the records. I have taken inspection of the lower court records, your Lordship. All the
That's why from this end, it is a request upon the learned advocate on record of both the sides to have an inspection during the course of this day.
yes, we have taken inspection. Let them take out. I will be there, Your Lordship, to assist.
In presence of both sides,
Yes.
let there be an inspection. শুনুন ওনারা দুজনেই থাকবেন দুপক্ষে আপনারা দেখতে দেবেন
এসছে
দেখে যেটা কি বলে করণীয় সেটা করবেন
Lordship, 17th, we have no issues.
ওই তাহলে কবে থাকছে 17 থাকছে হুম তাহলে অন কনসেন্ট অফ বোথ সাইড বলে let the matter appear if the documents are not there, then in that circumstance what will happen?
Lordship.
Your Lordship, direction to be given if any if we
Learned-
indicate certain
Learned
documents.
counsel, learned counsels, let be kept tomorrow
Yes.
under the heading to be mentioned to ascertain whether all the documents are there or not
Yes.
and to fix the date of hearing. If the documents are there, then
No problem.
date will be fixed.
Yes.
Otherwise, direction will have to be given.
Very well, Lordship.
এটা থাকুক on consider both sides. Let the matter appear tomorrow under the heading to be mentioned. Under the heading to be mentioned.
Grateful, Lordship.
আর আজকে ওনারা দুপক্ষই রেকর্ডটা দেখবেন ঠিক আছে
Item number 3.
Order to bear. Made, please, your lordship. Order to bear.
Yes, learned counsel, in which paragraph?
My lord, I have stated in paragraph 3, my lord.
Paragraph three.
Page 2 of
Place it.
In paragraph 22 of the order dated 1/7/2025, passed by the Honorable Court in CO number.
1 minute, 1 minute.
Lordship.
Paragraph 22 of the order dated 1/7/2025.
May I read it?
Yes, yes.
Yes. In view of the order passed in the civil division application, there should be an order for stay of all further proceedings in ejectment execution case number 125 of 2023, pending before the learned judge, second bench, Presidency Small Causes Court at Calcutta, till the end of the month of September 2025 or until further orders, whichever is earlier. it appears that in paragraph 22 of the order dated 1/7/2025, passed by the Honorable Court in place of ejectment case number 125 of 2023, it should be ejectment execution case number 125 of 2022 in place of 23. I've clarified that, my lord. Lordship, may I point out another thing? In terms of my lord's order dated 25th of August, my lord, in paragraph 11 and 12, it was mentioned as affidavit of service. My lord, it will be supplementary affidavit.
Oh, yes, not
Lordship,
affidavit of service.
I go down.
Nil. Nil. প্রথম করুন। In the order, in the paragraph number 11 and paragraph number 12 of the order dated 25th of August 2026, it has been mentioned as affidavit of service. Instead, it ought to be supplementary to supplementary.
Lordship.
Supplementary affidavit. Supplementary affidavit. 11 and 12. Affidavit of service. Instead, it should be affidavit, supplementary affidavit. ঠিক আছে? The order dated 25/8/2026 be modified to this extent only. ঠিক আছে? Next paragraph. Another supplementary affidavit has been filed today. Let it be kept with the record. Next paragraph. In paragraph number 3 of the supplementary affidavit filed today, it has been mentioned that in paragraph 4 korun, in paragraph 4 in paragraph 4 of the supplementary affidavit filed today, it has been specifically mentioned that there is no ejectment execution case number 125 of 2023 between the parties pending in any court of law. There is no ejectment execution case number 125 of 2023 between the parties pending in any court of law. Full stop. Paragraph. Taking into consideration the supplementary affidavit filed today and in continuation of the earlier order dated 25/8/2026, wherein it has been specifically mentioned that the legal heirs of the original tenant, that is the petitioner, legal heir or legal heirs?
Legal heir, one person.
Legal heir of the original tenant, that is the petitioner, was neither intimated nor any notice was served upon him as regards to any ejectment suit, and as such an ex parte decree of eviction was passed in the ejectment suit number 98 of 2014 by the learned Second Judge, Small Causes Court, Calcutta, wide order dated 22nd September 2022. And thereafter, an application under Order 9, Rule 13 was preferred by the petitioner, and the learned trial judge had been pleased to reject the said application on the ground that the petitioner was not living with his predecessor, that is the original tenant, at the time of the death of the original tenant. Next line. Being aggrieved by and dissatisfied with the order passed by the learned trial judge in respect of the application under Order 9, Rule 13 of the Code of Civil Procedure, the petitioner preferred a civil revisional application being CO 2257. If there is any
Lordship, I will.
wrong in number,
Lordship, I will.
mention then and then.
Lordship, I'll.
CO number 2257 of 2025, and the said revisional application was allowed by a coordinate bench of this honorable court, wide judgment dated 1/7/2025, and through the said judgment the following has been directed. এই পোর্শনটা আগের দিনেরই এই পোর্শনটা তুলে দেবেন। এই যে ইটালিক্স আছে, ঠিক আছে? হ্যাঁ হ্যাঁ, একদম এটা তুলে দেবেন। হ্যাঁ হ্যাঁ, একদম ইনভার্টেড কমা করে ইটালিক্স করে। In spite of the said order, the petitioner had thereafter sought for extension of the said order. When you had produced this order, the judgment dated 1/7/2025, was there any order passed by the learned trial court?
My lord, that order it's rejected, which I have under the revision
So
stay order.
impugned order is a sole order.
Yes.
After
No,
the,
thereafter it was fixed for hearing. Then after that.
কি হলো? In spite of the said order, the petitioner had thereafter no, চলে no, বাদ দিন কেটে দিন। The petitioner thereafter sought for extension of the order of stay via an application dated 20th December 2025, and the said application seeking extension of stay of the order of stay was rejected by the learned trial court. Full stop. In the meantime, the ejectment execution case number 125 of 2022 is proceeding and is fixed on 1st of September 2026 for delivery of possession with police help, and 3rd September 2026 for bailiff's report. Full stop. In such circumstance, next paragraph, in such circumstance, the petitioner, having no other alternative, has preferred the present revisional application, and this court is of the view that if the execution ejectment execution case number 125, ejectment execution case number 125 of 2022 is proceeded and possession is delivered with the help of police, in spite of pendency of the
Miss case 21 of 2023.
miss case
21 of
miscellaneous
2023
miscellaneous case number 21
of 2023.
of 2023,
Lordship.
21 of 2023, then it will be an injustice to the petitioner and will prejudice the petitioner. It will cause injustice to the petitioner and will prejudice the petitioner. In such circumstance, let there be an order of stay in respect of the ejectment execution case number 125 of 2022 till 30th September 2026. Paragraph. As copy of the application of the revisional application has not yet been served upon the opposite party or parties.
There are two.
Opposite parties. So the petitioner is directed to serve copy of the revisional application to the opposite parties and to file an affidavit of service on the returnable date. Let the matter appear on 16th. Let the matter appear on 16th of September 2026.
Grateful. Lord, I tender my apology once again. No, Lordship have been very kind enough to give me enough of time, and it was my mistake, my Lord. Otherwise, client would have been dire trouble. Grateful.
16th of September থাকবে, নোট নিয়ে নেবেন, বুঝেছেন? ওই প্রথম দিকে থাকবে। টপ কি খালি আছে? তাহলে 16th of September at the top. Next.
Item number 4 with 5.
At the top লিখে দেন।
Well, time for the petition. Your Lordship would recall, my lord, that matter. Lordship, my lord, heard it at length, my lord, on the last occasion, where, my lord, the application that was taken out by me
intends to provide one judgment in respect of Order 22, Rule 4 of the Code of Civil Procedure.
Yes, my lord, may I, should I, my lord, recapitulate the facts once more, my lord?
It will be better.
My lord?
It will be better.
Yes, my lord. Your Lordship, my lord, what happened, my lord, was my client was the defendant in the suit.
Suit for?
The suit for declaration and injunction.
Declaration and injunction.
Declaration and injunction. Now, my lord, my client was the defendant in the suit. Now, my lord, the suit was decreed ex parte on 15th of January 2009. After that, my lord, an execution case was filed by them on in 2013, being title execution case number 5 of 2013.
So, 2009 ex parte decree.
Ex parte decree against me.
Hmm.
Now, my lord, in 2013, my lord, title execution case was filed.
2013.
13.
Yes.
Thereafter, my lord, I took out an application that defendant number 6 died in 2003 prior to, my lord, passing of the decree. As such, my lord, the decree is a nullity, and the decree should be, and the suit was long back abated, and it should go. It cannot be executed.
Defendant number
6.
6.
Defendant number 6 died in 2003, and another defendant died in 2019. Another defendant died in 2019. Both of the defendants were not substituted.
Defendant number 6 expired in the year?
Both the 6 expired on 13th of February 2003.
13th of February 2003.
2003. That was the sum and substance of my application, my lord. On the last occasion, my lord, my learned senior friend, my lord, portrayed, my lord, before your lordship, my lord, order 22, rule 4, sub rule 4.
This defendant was not substituted against the dead person. The
Decree was passed.
ex parte decree was
Expert
passed.
decree was passed. Now, my lord, on the last occasion, my lord, my learned senior friend, my lord, took recourse of, my lord, order 22, rule 4, sub rule 4, my lord, where exemption, my lord, the court can, my lord, exempt a non-contesting defendant from, my lord, being substituted and pass a judgment as if the defendant had never died. Now, my lord, my lord, on the last occasion, my lord, submitted, my lord, before your lordship, my lord, that there has to be a specific, my lord, direction of the court. It cannot be an automatic process. The facts here are, my lord, that the death of that particular defendant was never brought before the learned trial court. The learned trial court, so the decree which was passed, there was no question of exemption at all. Since, my lord, the learned trial court was unaware of the fact, my lord, that the defendant number 6 had died. And, my lord, therefore, an exemption, if at all, that has to be specific and an application has to be made. Or even if I, my lord, say that an application need not be made, my lord, the court can do it on its own. My lord, there has to be a particular order, my lord, recording exemption of order 22, rule 4. Now, my lord, may I, my lord, place, my lord, one decision on this, my lord? On this court, my lord, the matter was, my lord, fixed today, my lord, that if any decision I find, my lord. My lord, this is, my lord, 2009, volume 14, SCC 294. Yeah. Learned senior friend is already, my lord, aware of this, my lord. This is passed by, my lord, Justice Chatterjee, my lord, as his lordship, my lord, then was in, my lord, Supreme Court, my lord. Kindly, my lord, takes up page, paragraph number 23 straight away.
Yes.
As noted hereinafter, a plain reading of order 22, rule 4, sub rule 4 CPC would clearly show that the court is empowered to exempt a plaintiff from the necessity of substituting the heirs and legal representative of any such defendant who has failed to file a written statement or who, having filed it, had failed to appear and contest the suit at the time of hearing of the same. But such an exemption can only be granted before the judgment is pronounced, and in that case only it can be taken against that the said defendant, notwithstanding the death of such defendant and such decree, shall have the same force and effect as if it was pronounced before death had taken place. Now, specifically, my lord, the Honorable Apex Court, my lord, holds that prior to the judgment, in this case, my lord, it was never done. No exemption application was ever filed. The fact was that the defendant number 6 had died was not brought before the learned trial court, and as such, my lord, the suit was passed, my lord, against a dead person. The decree was passed, my lord, against a dead person. Now, my lord, kindly, my lord, takes up paragraph number 25 of the same judgment, my lord, say. We are unable to accede to his submission of Mr. Ranjit Kumar, the learned senior counsel, appearing on behalf of the appellant for the simple reason that on abatement caused on the death of a defendant, the suit automatically abated in view of provision of order 22, rule 4, sub rule 3, CPC, and 2. From the decision in Zahirul Islam versus Muhammad Usman, it would be evident that no exemption was sought or granted under order 22, rule 4, CPC in the aforesaid decision. In my view, in any view of the matter, order 22, rule 4, sub rule 4 of CPC clearly says that such exemption to bring on record the heirs and legal representative of the deceased could be taken or granted by the court only before the judgment is pronounced and not after it. In view of our discussions made herein above, and after going through the provision of order 22, rule 4, sub rule 4, as discussed herein after, and in view of the principle laid down by the aforesaid decision herein earlier, and in view of the principle laid down by the aforesaid decision, it is therefore clear that if exemption which is provided under order 22, rule 4, sub rule 4 CPC is obtained from the court before the delivery of the judgment, in that case, it would be open to the court to exempt the plaintiff from bringing on record the heirs and legal representatives of the defendant, even if the defendant had died during pendency of the suit, as if the judgment was pronounced by treating that the defendant was alive, notwithstanding the death of such defendant, and shall have the same force and effect as if it was pronounced before the death had taken place. That being the position, we are therefore of the view that since in the case admittedly exemption was obtained after the judgment was pronounced, the provision of order 22, rule 4 CPC would not attract. Well, categorically, my lord states, and my lord kindly, my lord, takes up last Paragraph number 29, my lord, the very next page, my lord.
Yes.
For the reasons aforesaid, we are of the opinion that the High Court had rightly interpreted the provisions of Order 22 Rule 4, Sub-Rule 4 CPC, and accordingly held that a decree passed by the trial court on such and such date in OS number such and such was a nullity in the eye of law, as the defendant had died during pendency of the suit for specific performance of the contract for sale, and no exemption was sought at the instance of the appellant oblique plaintiff to bring on record the heirs and legal representatives of the defendant before the judgment was pronounced. Therefore, my lord, and it was held subsequently that, my lord, the decree goes, the decree is a nullity. Well, exactly, my lord, similar, my lord, situation arises here, my lord. Decree was passed long back. The fact that the particular defendant died was never brought on record of this of the learned trial court. I filed an application. The learned trial court, my lord, held that an ex parte decree cannot be abated. Probably, my lord, the learned trial court, my lord, is of the opinion, my lord, since there is a provision of exemption, although, my lord, the learned trial court has not specifically stated so, but held that no question to pray for abatement of an ex parte decree. Hence, there is no provision on CPC for abatement of an ex parte decree. But, my lord, specifically, I say, I submit, my lord, before your lordship, my lord, that Order 22 Rule 4, Sub-Rule 4 has to be specific. It has to be, my lord, there must be a prayer made in that respect. The reasoned order has to be passed, and this whole exercise has to be completed prior to pronouncement of the judgment.
So according to you, exemption ought to have been taken prior to pronouncement of
Prior
the
to pronouncement of the judgment. Cannot be, my lord, after the judgment, cannot be. Exemption was never taken. My learned senior friend, my lords, were taking recourse of Order 22 Rule 4, Sub-Rule 4. It has, my lord, I say, my lord, two things, my lord. It has to be, first of all, my lord, it has to be specific on a prayer of the plaintiff. The court has to pass a reasoned order, and this entire exercise should be completed prior to the judgment. In this case, my lord, the particular defendant died in 2003, and, my lord, judgment was produced in 2009. 6 years went on in between. My lord, that is, my lord, just only, my lord, this was, my lord, left to be shown on the last occasion, my lord. Grateful.
Actually, my lord, my learned friend is incorrect to say that the deceased defendant who died in 2003 and suit was decreed on 2009 ex parte against all the defendants excepting defendant number 1 and 2. Against all excepting defendant number 1 and 2. My lord,
So 1 and 2 had contested.
1 and 2 filed, my lord, solenoma, that is reflected in the judgment. My lord, if your lordships kindly take some more trouble, your lordships will find, unless and until I stand up to argue the case against the petitioner's case, there was no whisper in the judgment, in the submission as advanced by my learned friend, and there is no whisper in those two civil division case which we are arguing. No whisper about Order 22 Rule 4. No whisper. Order 22 Rule 4, Sub-Rule 4 only attracted, only come into play when I, my lord, placed it that the decree was passed ex parte and the deceased defendant never appeared in the suit. There was no story. Prior to, before your lordship, the 2CO, an order impugned, there is nothing that the deceased defendant has not contested, had not ever appeared in the matter. My lord, kindly have a look one by one the order impugned. There are two cases. Totally suppressing that thing that the defendant they never appeared. Contested is distant thing. Never appeared in response to summons.
Which one you are referring?
Well, first your lordships kindly see CO 1530 1513
Yes, 1513.
1513, wherein, my lord, the impugned order that the court below refused to stay the execution proceeding. My lord, kindly have a look. The application and order impugned. It is, my lord, order dated
18th of October.
18th of October 2023. So, my lord, 18th of October 2023, what is there? May I read it? The order impugned. My lord, got the order?
Yes, at this juncture, the petitioner.
Today is fixed for hearing of petition dated 6 September 2023. Both parties file hajira. Now the petition dated 6/9/2023 is taken up for hearing. The petition dated 6/9/2023.
Is there anybody?
No. Yes, this is my junior.
Is a stay petition. Is a stay petition prayed by the petitioner. That learned advocate for the petitioner has stated that the defendant number 6, namely Binu Bala Mondol, had expired 13/2/2003, and defendant number 8, namely Montu Dhali, has expired 5/6/2019. Both death was reported, but the suit TS 190/1995 was decreed ex parte 15/1/2009. Thus, the suit title 190/1995 stands abated. So, my lord, one thing, my lord. Binu Bala Mandal died 13/2/2003.
Bindu
Bala. And, my lord, defendant number 8, another Montu Dhali died, had expired 5/6/2019.
Yes.
So, my lord, if the expiry decree is 15/1/2009, there is no question of who died after that 5/6/2019. No business of the learned court below to consider whether he dead or alive.
No. The learned counsel representing the petitioner is banking upon the fact that Bindu Bala had expired on 13/2/2003. Prior to passing of the
expiry decree.
Prior to the expiry decree passed in the year 2009.
And, my lord,
So, as there was no
Montu Dhali, about Montu Dhali 2019.
About Montu Dhali,
nothing to do.
He is not agitating.
Yeah, it is the order in the order impugned. They banking on
Bindu Bala Mondol, death of Bindu Bala Mondol, not on the death of Montu Dhali.
So
Montu Dhali expired later on.
So order 22 rule 2 in execution proceeding, there is no role of order 22. We know it. In execution proceeding, order 22 rule 8. My lord, kindly have a look.
Volume 2/3 টা কোথায় গেল? Volume 2/3 টা কোথায় গেল? CPC ওইদিকে দেখুন, কাল লাগে। এখানে গুছিয়ে রেখে দেবেন রোজ, এখানে যেন গোছানো থাকে। 2টা ভলিউম 2টা ভলিউম 1 পর ভলিউম 2 টা থাকে। তো ট্রান্সিস্টেন্সি নামিয়ে দিন, আর এখানে 3 রাখতে হবে। পেন্সিল বার করে এখানে এখানে 3টা দিয়ে দিই। 3টা দিয়ে দেবো, ঠিক আছে? Sure.
My lord, order 22 rule 12, my lord, kindly see application of order to proceeding.
1 minute. Yes, application of order in proceeding.
Application of order to proceedings. Nothing in rules 3, 4 and 8 shall apply to proceeding in execution of a decree or order. So in execution, we are on execution. So in execution, if anyone comes forward with an application that some of the defendant died after the pronouncement of the decree, so we are on execution. So in execution, there is no role to play order 22 rule 3, 4. This is regarding, my lord, second death, Montu Dhali. Now, my lord, kindly see. Now, my lord, kindly see this. Who, my lord, filed this application? Who filed CO and who filed this application before the executing court? Whether that persons are the legal heirs of Binduwala Mandal or somebody else. Now, my lord, kindly see. My lord, who are before your lordships? So this is filed by one Sunil Dhali and Sushil Dhali. This CO, Sunil Dhali and Sushil Dhali.
Yes.
Well, kindly takes up the cost title.
Yes, Sunil Dhali
and Sushil Dhali, both sons of late Bhagyodhar Dhali.
Yes.
Sunil Dhali, Sushil Dhali, both sons of late Bhagyodhar Dhali. Now, my lord, kindly see second CO, who is the petitioner before your lordships?
Connected CO to the 2814. Filed by the same persons.
Sunil Dhali, Sushil Dhali. And if your lordships kindly takes up the order impugned, order impugned is order dated 22nd July 2024.
Yes.
And my lord, kindly see the order. 21st July order. 22nd July order. Today is fixed for further argument and payment of cost of rupees 600 by the petitioner. Petitioner means the JDR, because they filed application for abatement. That miscase. So miscase has been filed, not the legal heirs of that deceased defendant.
So judicial miscase 98 of 2013.
Yes.
1 minute.
So both the parties files Hajira, petitioners again files order of the Honorable High Court.
Counsel, this one is seeking abatement.
Seeking abatement. So, my lord, I just, my lord, want to draw your lordship's kind attention. This order 22 rule 4 sub rule 4 is nowhere. Now, my learned friend, when I, my lord, pointed it out that there is no necessity of substitution, since because the deceased defendant never appeared in the suit. That was not their case. I pointed it out in order to get them, my lord, disarmed of this CO, because whether the suit is abated or not abated, whether order 22 rule 4 sub rule 4 was required to take, my lord, the leave of the court so that court can exempt the plaintiff, that is not his case. And that's to be adjudicated by whom? By the trial court. By the trial court. This is not the final place of hearing of or adjudication whether application filed by the any of the defendant alleging that the suit has been abated. So ultimately that to be adjudicated by the court below. And petition was there and argument was concluded from the impugn order it is appearing. So argument, so my lord,
It is fixed for further argument.
further argument. So that to be abatement issue to be decided by the court below. I am before your lordships, I am praying for that let the court be decided the miss case filed by the petitioner. Unnecessary staying the execution case will not serve the purpose of anybody, but it can serve the purpose of judgment debtor, but it will not judicially serve the purpose of anybody, mainly the petitioner. So why I am showing all this order? Why I am showing the person who is filing who has filed the present COs?
There is only one judicial miss case, that is 98 of 2000.
That is abatement.
That
They
is seeking abatement.
seeking abatement, my lord.
Apart from this, there is no other miss case.
No other miss case. Now, my lord, kindly see.
1 minute, 1 minute. Yes.
Now, my lord, kindly see the solemnum.
In which
Before that, your lordship kindly see the expiry decree itself.
in which one you have annexed? CO 2814.
The CO is there. I have no opportunity to annex.
So it is not before the court. Is it before the court?
My lord. Yes. My lord, in the expiry decree, my lord, PW1, PW2 corroborated the plain case in material particulars. The DS accord and marked exhibit 1 reflected that yes, some of the defendants filed solely. My lord, kindly have a look. এটা কপি করেছেন some of the defendant filed solenama. My lord, so there is a existence of solenama mentioned in the my lord expiry decree, my lord, and solenama filed were some of the defendants. Now who filed solenama? I have served one copy on last day. Copy of solenama.
কোনো কিছু আছে দেখুন তো এখানে কোনো envelope আছে এতে এটাতে কোনো envelope আছে?
কোর্টকে দেওয়া হয়েছে? ইয়েস।
দাঁড়ান। রিপোর্ট নয়। No, Mr. Poddar. Mr. Poddar, there is no copy.
My lord, I will provide again, my lord. My lord, kindly have a look, my lord. This Solenama Patro, my এটা একটু দেবেন।
Yes.
Solenama Patro, my lord, kindly see, my lord, left hand top, who were the signatory of this Solenama. One of them, one of the three is Bhaggodhar Dhali. One of the three is Bhaggodhar Dhali, one of the signatories.
Yes.
And now, my lord, kindly see the parentage of present petitioner, Sunil and Sushil, son of late Bhaggodhar Dhali. So, my lord, that Sunil Dhali and Sushil Dhali, they are not the legal heirs of the deceased defendant. They are not coming forward. More so, their father was the signatory of the Solenama. So, being the legal heirs of a defendant who participated in the Solenama and which is the part of the ex parte decree admitting the plaintiff's case in the court below, how they, my lord, on demise of his father, they can maintain this application before the learned trial court or before this honorable court? I am putting question to myself. What legal authority, what locus standi this Sunil Dhali and Sushil Dhali has? They are not the legal heirs of Bindubala Mondal. But it is my question to myself. If that be so, that may be a question for consideration before this learned court below.
And
so,
and the judgment was passed on the basis of the Solenama.
Solenama, my lord, admitting
the predecessors of this petitioners
was the signatory.
One of the signatories.
One of the signatories. My lord, can this application either before this court before learned trial court or before this court regarding the death of one of the Bindubala Mondal died during the pendency, it arise in their mouth? So, my lord,
anything more?
Many things more, my lord, is there, my lord, because and the judgment. So, my lord, I just wanted to convince your lordships at this juncture, Order 22, Rule 4, Sub-Rule 4 of Code of Civil Procedure can't fit to be accepted from their mouth, and court will not accept it because their stand was that as if that Bindubala Mondal died during contesting the trial court proceeding, and knowing fully well plaintiff had not substituted the legal heirs of the deceased defendant, as if it is his case. So when he caught that He has no locus, the deceased defendant or the heirs of the deceased defendant has no locus tenens to maintain any application praying for substitution and non-substitution of the legal heirs of Binduwala Mandal makes the suit abated. Not fit in the mouth of my lord Sunil Dhali, Sushil Dhali, who are before your lordship, because they are not the legal heirs. And they never disclosed it. They fraudulently made application. For that reason, court below in the order impugned, my lord, in 1513, observed that it is order impugned, it is reflected.
Suppose that this is second appeal or civil revision?
Civil division, my lord. So it is said that there is.
My submission, I got confused.
Well, from my submission or it is my reply, my lord. It is my
reply to reply.
No, not reply. In fact, my lord, your lordship is perhaps correct, my lord. But I wanted to submit that order 22 rule 4 sub-rule 4, it is not his core to submit, because case was initiated not on that basis.
That could not have been raised by them.
Them, my lord.
Yes.
This is.
Yes.
And if your lordship, my lord, ask me to answer the judgment, he showed, that is judgment delivered by Honorable Justice Tarun Chatterjee, my lord, he is referred to all of us, my lord. But the judgment is not fit in this case, because in that judgment,
that you say, why?
Yeah, why? In that judgment, there was sole defendant, number one.
Where it is mentioned the sole defendant?
Yes, that paragraph 4, 15, 16, my lord, 2 paragraph. That is I also, my lord, I gone through those that judgment.
Gone through the same.
My lord.
Yes, specific performance of contract.
Yes, my lord, there are 2 suits. One is eviction, and another eviction suit was decreed. And my lord, the judgment dated defendant filed 1 suit for specific performance.
Wherein it is mentioned? Defendant?
It is there, my lord. Kindly see.
Which paragraph?
এই তোমাদের কাছে কপি আছে? ওটা একটা কপি দাও।
You mentioned that the respondents who are the heirs and legal representatives of the defendant.
Yeah, my lord, there are 2 suits. This is arises, my lord, in my lord, suit for specific performance by the tenant.
Yes.
After he suffered a decree.
And
my lord, that suit, my lord, defendant, my lord, decree holder died. Decree holder was contesting, and thereafter decree holder died. The suit was placed on expertise, and expertise that suit of specific performance was also a decreed expertise. In that expertise proceeding, my lord, the landlord's legal heirs came forward and alleged that this is abated because, knowing fully well the plaintiff decree holder has not, my lord, substituted the legal heirs of the landlord. My lord, I am coming to that portion, my lord.
paragraph 6, we mentioned here that during the pendency of the suit for specific performance of
Yes,
the
yes.
person, the defendant died. The death of the
Yes.
defendant, however, was not brought on record by the plaintiff
Yes.
appellant. Thereafter, without the knowledge of such death, the trial court passed an ex parte decree
For specific performance of the contract. So, my lord, kindly see. Here, my lord, a defendant was sole defendant. My lord. Here, my lord, by practicing fraud, there is, my lord, max of malafide is appearing, and that smell was gone to the court. The court perceived the practice exercised or adopted by the tenant decree holder in specific performance of contract suit. And my lord, in our case, there are as many as, my lord, more than 20 defendants. My lord, kindly have a look. In our suit, my lord, there are, my lord, 23 defendants. And what is the nature of the suit?
Declaration or injunction?
What declaration, my lord? Declaration is, my lord, my claim is based on, my lord, that I am the legal heirs of one Nitai, and I having, my lord, or Nitai having 3 sons, 3 legal heirs, and my client is false from Akhoy. My lord, I submitted on last occasion the copy of my genealogical table along with, my lord, expert that Solenama and my lord. So, my lord, all these 23 defendants, they are legal heirs of different bunch of Nitai Dhal. And, my lord, some of the defendant, my lord, admitted that by wrongly my predecessor's name were not recorded in the record of rights, so far as our share regarding 1/6 of the total share as mentioned in the Schedule A.
So the judgment cited on behalf of the petitioner is not applicable. Herein,
2009-14.
there were several defendants and not sole defendant.
First thing, there were sole defendant. Second thing, say that defendant was participated, filed written statement, contested the suit. And in our case, there are as many as 23 defendants, and the deceased defendant never appeared in the matter despite summons. And, my lord, this is a suit not against him, and even that not only against her. And, my lord, suit will not be abated because all other defendant, my lord, by filing Solenama, admitted the claim of the plaintiff, So, in no circumstances, the suit will be abated. And no circumstances that Bindubala Mandal or anyone who are non-contesting, non-appearing defendant, it is there, my lord, there is no requirement to substitute or my lord, take, my lord, leave of the court for praying for exemption. So, my lord, I am showing, my lord, one judgment, my lord, parent judgment, that is, my lord, delivered by
Counsel, you are referring to a judgment at the stage of hearing of the reply to the reply. Why are you doing this?
My lord,
it is a never-ending process.
It is legal test because I am just wanted to submit what my learned friend today submitted. He has no right to submit regarding order 22 rule 4 sub rule 4.
So why did
just to discern him from the submission which he advanced today.
Why didn't you refer it on the earlier occasion?
Earlier occasion, I already said, he said that I will cite some judgment. So the judgment which is cited, in reply to that judgment, I am replying. That judgment is not applicable here, and because he can't utter a single word over order 22 rule 4 sub rule 4.
Refer to that.
And, my lord, this is AI 1963 Calcutta. This judgment by P.B. Mukherjee's judgment, my lord, Honorable Justice P.B. Mukherjee, my lord. My lord, kindly have a. I am, my lord, referred, my lord, only 2 paragraph, my lord. My lord, that contention is this, my lord. In a suit, when the
reference.
Yes, 1963 Calcutta 520.
1963 Calcutta
520. Judgment delivered by Honorable Justice P.B. Mukherjee.
Provide a hard copy, Lord Counsel.
And C.N. Laik.
Mr. Poddar,
Yes.
provide a hard copy. Can you provide a hard copy?
Yes, I get it, Xerox.
Obviously, the book is of the bar, not
My lord,
yours.
my lord,
The book is of the bar.
yes,
That's why. Otherwise,
because it is before my birth. How could I?
no, if that would have been from your library, then you shouldn't have got a photocopy of the same. Yes. Which paragraph are you referring?
My lord. My lord, paragraph 16. Paragraph 16. Lastly, Mr. Meter contends that this appeal is incompetent because of the sixth defendant, because of sixth defendant minorly died during the pendency of this appeal, and the appellant has taken no steps to substitute her. Here, who we are told was a daughter. The point has a seeming attraction, but has no substance. The point has a seeming attraction, but having no substance. As stated already, Minalini was alive when the plaintiff instituted the suit, and when the judgment under the appeal was delivered. She never entered appearance. She never entered appearance. She did not file any written statement. She never contested at the trial court. In fact, she took no part. The next fact which is to be remembered is that she is only pro forma defendant and no more. So, my lord, in case of, my lord, death of pro forma defendant, we should treat this death accordingly. That is a pro forma defendant, because one who was not interested at all. So on her or his death, her legal heirs can't come forward and ask for to be for impleadment.
That is all.
Kindly have a look, my lord.
No.
Only, my lord,
I'll go through the soft.
three paragraphs.
I'll go through the
three
soft,
lines.
soft copy.
3 lines. It is for my satisfaction, because this judgment, PV Mukherjee.
That's all.
Well, one more judgment after the judgment cited by my learned friend. It is 2013 SCC. It says the court was right enough. Court was right enough by not substituting the deceased defendant legal heirs when deceased defendant had not participated in the suit. During his lifetime.
Yes.
So, my lord, what my learned friend, just to analyze the judgment in his favor, that when the
please come to an end by
Yes.
referring to the last.
Yes. That the exemption to be obtained before delivery of judgment. So, my lord, there are as many as 23 defendants in our case. 2 participated by filing solenama only. And, my lord, accepted the plaintiff's PW1, PW2's version. So, my lord, if any non-attending defendant dies, my lord, it is the incumbent duty on the part of the other defendant to inform the learned court or the plaintiff. It is whose duty, my lord? I am putting question to myself. If any defendant died, contesting or non-contesting, contesting is the issue. if any defendant died, it is the duty of his learned advocate to report the death of the said defendant. Is it not, my lord? We know it all, that it is a duty of the lawyer concerned of the deceased defendant to report about the death of his client. So, my lord, if that was done, in that event, my lord, my client the plaintiff may seek for, my lord, exemption. It is a mere formality. It is a mere formality. Unless it was informed to the court, unless the death is reported to the court, how the court will know, or how the plaintiff will learn about the death. It is not that they are staying in one place. So, my lord, this judgment is say about that. My lord, 2013, volume 9, SCC, page, my lord, 642. 642. I am only paragraph 31, 1 to 3. 31.1, my lord,
31.2
point 2.3. It is not a matter of dispute that Sushil Kumar Chakraborty had died 3rd June 2003. It is also not in matter of dispute that on 29th August 2003, the plaintiff Tej Properties had filed an interlocutory application being IA number 9676 of 2003 under Order 22, Rule 4, Sub-Rule 4 of the Code of Civil Procedure for proceeding with CS number such and such ex parte, by bringing to the notice of the learned single judge that Sushil Kumar Chakraborty had died on 3/6/2003. That being the acknowledged position, when the learned single judge allowed the proceeding 2501 to progress further, it is imperative to infer that the court had taken conscious decision under Order 22, Rules 4, Sub-Rule 4 of the Code of Civil Procedure to proceed with the matter ex parte against interest of Sushil Kumar Chakraborty, without first requiring Tej Properties to implead the legal representative of the deceased defendant. It is therefore that evidence was recorded on behalf of the plaintiff therein that Tej Properties on 28 January 2005. Now 31.2. In the aforesaid view of the matter, there is certainly no doubt in our mind that, being mindful of the death of Sushil Kumar Chakraborty, which came to his knowledge through IA 7696 of 2006, a conscious decision was taken by the learned single judge to proceed with the matter ex parte as against the interest of Sushil Kumar Chakraborty. This position adopted by the learned single judge in CS number 2501 1997 was clearly permissible under Order 22, Rule 4, Sub-Rule 4 of the Code of Civil Procedure. A trial court can proceed with a suit under aforementioned provision without impleading legal representative of a defendant who, having filed written statement, has failed to appear and contested the suit if the court considered it fit to do so. My lord, here
has been referred
my lord,
earlier.
my lord, here, my lord, filed written statement. My lord, here, my lord, no appearance. So, my lord, this will help me, my lord. Though, my lord, it is not, your lordships could not see the judgment of 2009 because it is beyond the scope of the case.
Provide a copy of the solenama and the
expiry decree.
expiry decree. And along with that, you provide that genealogy also.
Well, kindly read one paragraph.
I'll go through. It is noted down. I'll go through.
I'm furnishing, man.
I'll go through.
Deeply obliged. So, my lord, in sum and substance, my lord, my prayer is, my lord, let the court below be decided the application, whatever they find. They only seeking stay of execution. They are saying we have nothing to say excepting the order of the High Court. It is their contention. My lord, your lordship has gone through the impugn order. So, my lord, my respectful services before your lordship, the execution proceeding has remained stayed.
Hmm.
How long, my lord? Until and unless disposal of Miss Judicial case 98, which they filed. So, my lord, there is not required to stay of the further execution proceeding. Let the 98 Miss Judicial case filed by the petitioner be disposed of. Argument has been advanced by the court before the court below by the respective parties, my lord. So only it is the court to deliver judgment, my lord. So, my lord, because of this stay, because they are misinterpreting this stay, and they as many as 3 civil division applications they, my lord, preferred. As many as 3 without filing even any miscase under order 9 rule 30.
Before this court, there are 2.
There are 2. One is already disposed of. So what was the substance of that 2? Those 2. So, my lord, let the court below be decided. Whatever the pending miscase is there at the instance of the judgment data, then let that be decided. No question of further stay.
Heard the learned counsel representing the petitioner and the learned counsel representing the opposite party. Full stop. The learned counsel representing the petitioner. The learned counsel representing the petitioner has referred to a judgment of the Honorable Apex Court published in 2009, 14 SCC, page 294. While the learned counsel representing the opposite parties has referred to 2 authorities, one being AIR 1963, Calcutta, page 520, and the other being 2013
expiry decree,
volume 9, SCC, page 642. Full stop. Argument is concluded. Reserved for judgment. যেগুলো লুজ যেগুলো দিয়েছে সাইটেশন এনভেলপে রেখে দেবেন, কেন হারিয়ে যাচ্ছে কিন্তু কিছু কিছু কাগজ দেখবেন হারিয়ে যাতে না যায় কাল।
I must kindly take a note. Who is before your lordship? Who challenged the date?
Provide a copy of the Solenama and the others.
Yes. Who are before your lordship? Who challenge? Who, my lord, come forward, my lord, alleging the date?
That you have shown.
এটা আলাদা করে এখান থেকে 16 নম্বরটা বার করে দিয়ে দিন। আচ্ছা 16 নম্বরটা আমি জজ সাহেবকে দিয়েছি, ওটা কি ব্যাক করেছি? ওটা দিন জেরক্স করুন। জেরক্স ইমিডিয়েট দিয়ে দিন। জানি deeply obliged.
Yes. Next double.
Item number 6.
On the earlier occasion, that is on 10th of August 2026, none had represented the parties. Today also, none is representing either the petitioner or the opposite party. In such circumstance, let the matter be dismissed. The matter is dismissed for default.
Item number 7.
Display হচ্ছে display হচ্ছে same order dismissed for default.
Item number 8.
Same order.
Item number 9.
Same order. Dismissed for default.
Item number 10.
আজকে কোনো resolution নেই তো? Same order. Dismissed.
Item number 11.
Din. Same order. Dismissed.
Item number 12.
Your Lordship, item number 12, Mr. Shondeep Das is appearing for the petitioner. He's on his way, Your Lordship, just bring for a short pass over. He's on his way, Your Lordship.
Passed over. Passed over.
Item number 13.
12 টা পাস ওভার হলো।
Pass.
নোট রাখুন। অন্যগুলো কিন্তু ডিসমিসড হয়েছে। 12 টা পাস ওভার হয়েছে।
Item number
13 ডাকুন। ওইখানে চেঞ্জ করছেন তো, ডাকার সঙ্গে সঙ্গে চেঞ্জ করছেন। On the earlier occasion, that is on 10th of August 2026, none had represented the petitioner. Today also, none is representing the petitioner. In such circumstance, the matter is dismissed. For default.
Item number 14.
None had represented on the earlier occasion, that is on 10th of August 2026. Today also, none is representing. In such circumstance, let the matter be dismissed for default. The matter is dismissed for default.
Item number 15.
Same order.
Item number 16.
Same order. Dismissed for default.
The 12 will be taken up today. I think 12 time for the petition.
Dismissed for default.
No, I for the petition. Malad.
Oh, 12, acha. Passover, acha. It will be taken up after item number 22. It will be called once again.
Item number 17.
Same order. None had represented on 10th of August 2026. Today also none is representing the petitioner. In such circumstance, the matter is dismissed for default.
Item number 18.
Item number 18, same order. Dismissed for default.
Item number 19.
19, my lord, I am for the opposite party, husband. নামগুলো লিখে দে।
First time it is appearing.
No, this is not the first time. This has already been
No, by this bench.
before this bench, yes. My lord, in this matter, they have served a notice that they will mention the matter before the court number 2. Thereafter, this has been listed before this court without any notice, my lord. From the list, we just found that this has been listed before this court.
দেখি mentioning slip টা দেখি এর সাথে গাঁথা থাকবে mentioning slip বার করুন দেখি
Initially, notice served upon us intimated that this will mention before the court number 2.
mentioning slip এখানে কোথায় endorsement আছে অপোজিট পার্টির ডাইরেকশন দেওয়া আছে কি ডাইরেকশন দেওয়া নেই আপনাদের আপনাদের ডাইরেকশন দেওয়া আছে তো যে আদার সাইড কে নোটিস না সার্ভ করে এন্ডোর্সমেন্ট না হলে নেবেন না বলা আছে তাহলে এগুলো কি বাংলা ভাষা আপনারা বোঝেন না নাকি
দিনেশ শর্মার করে দিচ্ছে হ্যাঁ কোথায় আমাদের কাছে কোনো ইন্টিমেশনই নেই দিনেশ শর্মা আমাকে নোটিশ
Honored Counsel, it has been mentioned to be included without serving copy upon the other side.
Well, may I
There is
just
no
check?
endorsement to that effect.
Well, may I just check?
No, this is not being encouraged.
Well, let me just check. Well, I'll just revert.
Check. আর আপনাদের বারবার বলে দিচ্ছি কিন্তু ডাইরেকশন গুলো ফলো করবেন।
Dinesh Sharma and another before Justice Milord, Honorable Justice Shompa Dattopal. These two Milord affidavit of service I have. Milord, these are the two affidavit of services I have. Now, Milord, if your Lordship so desires, Lordship kindly keeps it any other day, Milord, so that my learned friend also can prepare herself and Milord, let us come back.
Are you prepared?
Yes, let him start first, ma'am.
Start. But
Milord,
this
I
should not
understand.
be.
Milord, I understand. Milord. Milord, we, by virtue of the order impugned, if your Lordship kindly considers, Milord, the maintenance amount, Milord, which was, Milord, this is
So,
this,
out of matrimonial.
my lord. Milord, this has a checker history. Why I say, Milord, in the earlier occasion, when we come up before this honorable court, Milord, challenging Milord the order of maintenance, Milord, this honorable court, my lord, Mr. Justice Ajay Mukherjee was pleased to pass an order directing Milord the learned trial court below to Milord hear it, Milord, on the basis of affidavit of assets, Milord, submitted by us, by both the parties. Milord, now, Milord, on the basis of that, and his lordship was also pleased to pass an order that the interim, Milord, interregnum period, Milord, pendency of the disposal, Milord, the husband will pay Milord 1 lakh rupees per month. Milord, this was the interim direction passed by Milord Mr. Justice Mukherjee. Now, Milord, thereafter, Milord, what happened, Milord, the learned judge in the court below was pleased to, Milord, dispose of, Milord, the interim application for maintenance on the basis of affidavit of assets submitted by both the parties. Now, Milord, my humble challenge before this honorable court are twofold. Milord, the first part is that, Milord,
Let's take up the impugned order.
Lordship.
Why it is so much voluminous?
Milord, it has the affidavit of assets also. Milord, I have annexed.
5 volumes are here, madam.
Milord, the order impugned is dated, Milord, March 11, 2024. Your Lordship will get it at, Milord, volume.
5.
Yes,
Dated
Milord, March 11, 2024. Milord,
March 11.
Milord, I'll just indicate, Milord, the page number, Milord.
How much?
Milord, for the purpose of
It's
Milord
11
saving
March
time,
2024.
Milord, may I humbly submit one thing. Milord, may I come back tomorrow, Milord, with a 1-page note, Milord, indicating the page numbers. Otherwise, it will be difficult for your Lordship, Milord, to Milord, shift, Milord, from one volume to another. Or, Milord, subject to your Lordship's convenience, Milord, day after, Milord, your Lordship kindly, Milord, I'll make a, Milord, page-wise, Milord, a chart, Milord, indicating, Milord, the page numbers.
What to be done?
Kindly post it, Milord, for tomorrow, Milord, subject to your Lordship's
No,
kind
tomorrow.
convenience.
Tomorrow I have some difficulty, madam. Tomorrow not. Day after tomorrow. Monday.
Milord, Monday, I have some, Milord, Monday and Tuesday, I have some personal difficulty. Then, Milord, maybe on Wednesday.
Nil. The learned counsel, representing the petitioner and the opposite party seeks an accommodation for this day. Full stop. Let the matter appear on 14th কতগুলো ডেট দেওয়া আছে? 14th কতগুলো ডেট দেওয়া আছে? Let the matter appear on 14th of September. You have difficulty?
No, I'm told, Milord, your Lordship, Milord, will be
Circuit. For the
maybe on day after tomorrow. Milord, may I just start, Milord?
day after tomorrow, this court won't be available.
Oh, Milord, tomorrow, Milord. 14th, Milord.
14th of
Grateful, challenge.
14th of September. As this, ওখানে লিখে দেবেন, as this bench won't be available during the
My
forthcoming.
lord, 14th, I have some personal difficulty as 14th is Ganesh Chaturthi, my lord.
From the bar, which date?
17th. But any day after 14th, my lord. 14th, I have some personal.
15th দেখুন, 15th দেখুন তো।
15th. আচ্ছা, হাবড়ি যুদ্ধ সকাল সকাল হয়। একে তো।
থাকুক 15th এ থাকুক। 15th of September.
Grateful, Your Lordship.
হ্যাঁ, ওটা লিখে দেবেন। Bench will be in circuit for the forthcoming fortnight.
15th.
Grateful. না, পাস হবে কেন? ওইখানে ওই 22 অব্দি ডাকুন, তারপরে পাস ওভারটা ডাকবেন। কুড়ি ডাকুন।
Item number 20.
20, my lord, I am for the opposite party number 1.
On the earlier occasion, an accommodation was sought for on behalf of the appellant, and today none is representing the appellant.
And the petition is a civil revision.
Oh, civil revision, তাহলে appellant কেন লিখেছে? For the petitioner. Actually, এটা for the end. For the ends of justice, let the matter appear on 16th as 16th of.
I am grateful, Your Lordship.
ডেট গুলো কিন্তু ঠিকঠাক করে নোট করবেন। নেক্সট,
Item number 21.
Lord, I beg to appear for the opposite party.
has the copy of the revision?
Yes, but the revisional application
Provided.
it has been provided. Now difficulty is this, my lord, I am being unnecessarily being prejudiced. Why I tell your lordship? Plaintiff brought a suit against me, suit for declaration of title. Now I filed my written statement and my written objection to the injunction application. My lord, prior to my filing of the written objection, the ad interim injunction was allowed. Now, the power of attorney executed by the defendant, my lord, there was some irregularity. They took up this issue before the learned trial court. The learned trial court thought it fit that it is curable, and that has been cured. My lord, the written statement has been accepted by dint of the order impugned. Now they have come up against this. Now there is an interim order passed by this honorable court. As a result whereof, my lord, the injunction application could not be heard till date. Now they are taking advantage of the pendency here. Your lordship would kindly takes the interim, the order impugned once. Kindly takes order number 13. Prior to that, my lord would kindly first take order dated 6/9/2023.
Yes, 6/9/2023.
My lord will find this is an ad interim order of injunction. This ad interim order of injunction was passed. Thereafter takes the order impugned, order dated 13th of March 2025. Yes, sir. My learned senior friend has come.
I'm for the petitioner. Now, just to be
আমার পিকটা নিন।
13th of March 2025, yes.
That is the
Order number 13.
yes, that is the impugned order.
Hmm.
এই তো স্যার ব্রিফ এসে গেছে।
All for the opposite parties.
I am petitioner.
Petitioner.
Short point involved in this case, my lord. Defendant number 1 has filed the review statement and the written objection to a power of attorney,
To a constituted attorney.
to a constituted attorney. My lord, that constituted attorney is defective and it is in contravention to the provision of section 84 of the Old Evidence Act and New Evidence Act. New Evidence Act. Why, my lord? First, my lord, your lordship kindly look into the my lord, the order number 4 dated 20th page 11 annexure A, my lord. Order number 4 20th December,
Page 11.
December.
Yes.
Defendant number 1 filed in statement and it is an objection this day with a photocopy of Amuktanama be kept in this record, copy served. This is the next page, my lord, B12, annexure B, 12, page 12, my lord. The power of attorney or Amuktanama.
Yes.
Here, my lord, the last page, page 16 of the Amuktanama, Onion Mighty. Sakhigot, it is not necessary, my lord. Not identified by lawyer. The Onion Mighty was also not identified by a lawyer. This is what is a peculiar feature of this document.
No other card is not removed.
And my lord, the other card was also not filed in this, as well as my lord, the original
not
Amuktanama was also not filed to this file.
What was not filed? The second point, what was not filed?
This,
Identity.
my lord, this is not identified by a lawyer.
That's the first point.
Why, my lord?
Second point?
Second point on the original Amuktanama has to be filed on the
Not-
power of attorney,
not
not filed, my lord.
Okay.
Got it?
What was the order in respect of these two things raised by you?
My lord, thereafter, my lord, we filed an application under
this
section
regard?
151, my lord, page 17, annexure C.
Yes.
Whereby we have stated, my lord, that this is not tenable, this paragraph 8, my lord, that your petitioner state that in the general power of attorney, no advocate has identified the opponent's signature. As such, it very much doubtful and false to the knowledge to the deponent and falsification before the court of law. The paragraph 9, my lord, the petitioner state that the Bhogaladna filed by the defendant number 1 on 17th October 2023 was not signed and authenticated by the defendant number as there was some other signature is thereon. That is with the Bhogaladna one also. And paragraph 7, my lord, the last sentence, not attached with the identified proved by the Aadhaar card.
And in at this disclosure, where is state? Where is state?
And the deponent, the defendant number 1, where is stays, well, that has not also been disclosed to the court and to the party. In the power of attorney.
Yes.
Well, this is also peculiar, where the learned lawyer also not identified the signature of the holder of the
any authority of notary public or court.
and second, my lord, under the provision of the 84 of the Evidence Act,
Evidence Act.
the
Evidence
new Evidence Act, Bharatiya Sakya Odhiniyam 2023. 84 says this, my lord.
সাক্ষ্য
The
অধিনিয়ম,
court.
ভারতীয় সাক্ষ্য অধিনিয়ম ওইটা
They will
নতুনটা।
do that.
You are referring to the old one or new one? সাক্ষ্য অধিনিয়ম or Evidence Act? Which one?
Evidence Act, the new one, I have just.
New one. ভারতীয় সাক্ষ্য অধিনিয়ম।
ভারতীয় সাক্ষ্য,
Same,
same, my lord.
85 or 80.
My lord, the old one's 85, new is 84.
Verbatim.
Agree, then আমার
84 of the Evidence Act. Yes.
Section 84,
Yes.
by the new act, Bharatiya.
So, Learned Counsel, you place for the new act.
My lord,
Yes.
I'm reading new act, my lord.
Yes. They are in 84.
84.
Earlier, it was
85.
85, yes.
The language same, my lord.
Yes, place.
Only the numbering has differed.
Yes.
The
Please.
court, kindly mark the language, the court shall presume that every document purported to be a power of attorney and to have been executed before and authenticated by a notary public or any court, judge, magistrate, Indian consul and vice consul, etc. So, my lord, every document has to be executed before and authenticated by notary public or any court, judge, or magistrate, as the case may be.
This power of attorney not
This
authenticated
power of
in
attorney, my lord, has not even been authenticated
by the authority.
or any authority, my lord, either notary public, court, or judge, or the magistrate, as the case may be. So there is a clear violation of the mandatory provision of the Evidence Act or the new act. ভারতীয় সাক্ষ্য অধিনিয়ম কি বইটা?
Yes. Anything more, Learned Counsel? Anything more to be submitted?
So my conclusion before Lordship, the written objection and the written statement is not to be considered at all in view of this provision of the mandatory provision of the Bharatiya Sakkho Ain, and the London judge was relying on the Supreme Court, my lord, that is 71 Supreme Court, page, my lord, 761. This is a case of my lord, the sale deed. My lord, the paragraph 6, page 764.
Judgment being relied by learned Singh.
Paragraph 6, my lord. It is plain that presentation for registration could be either by the principal or by duly constituted attorney. It is equally plain that a proper power of attorney
Learned
duly
Counsel, you are relying
authenticated
upon
and required by law
Learned
has
Counsel.
to be made before power of
Learned Counsel,
attorney.
you are relying upon 1970, volume 2.
No, my lord, 1971 Supreme Court, SC, page.
That is SCC.
Yes, this one is also SCC.
He's relying on AIR.
I am
AIR.
AIR, my lord.
Case between Jugraj Singh and another versus
Jugraj Singh and another versus
Jaswant
Jaswant Singh.
others.
It is from 1867 Punjab. Chief Justice
Chief Justice Hidayatullah,
Justice and I.D. Dua.
Acha. So, yes, Learned Counsel, you can place.
So paragraph 6, my lord. Section column.
Please.
Either by the principal or by the duty constituted. It is equally plain that a proper power of attorney duly authenticated and required by law had to be made before power could be concerned or another either by to execute the document to be present. It is for registration. That means is indeed in the law. Means it by support by contention that documents
must be authenticated by the.
It is plain that presentation for registration could
Yes,
be
yes, my lord.
either by the principal or by a duly constituted attorney. It is equally plain that a proper
Power
power of
attorney.
attorney duly authenticated as required
By
by law
law.
had to be made before power could be conferred on another, either to execute the document
You
or
are
to present it for
anyway
registration.
presented the presentation. So my conclusion is this, it must be complied with the section 84 of the Bharatiya Sakhain or the 85 of the old evidence act. So this order there is two infirmities in this, and this case law does not apply either in the fact or in the principle so law.
Yes. Anything more? Anything more?
My lord, the document your lordship will kindly look into once again. That my lord, page 16.
Yes, page 16.
Page 16. The Amukta Datar Sakhak, Anjan Maiti, not identified even by a lawyer.
You have stated. You have
Yeah,
stated.
right. Already I have said. Why he absent not to execute it? That is page 14, my lord. Internal page 3.
Yes.
এতক্ষণে তফসিল সম্পত্তি বাবল নির্মল কুমার নামার বিরুদ্ধে ইন দি কোর্ট অফ দ্য লার্জেস্ট জাজ সিটার ডিভিশন বলতে এস নামার সাতেন আমি আমক্তাদাতা কর্মসূত্রে রাজ্যের বাইরে বসবাস করায় ও অন্য মোকদ্দমা আমার পক্ষে আদালতে নির্ধারিত সময়ে রেগুলারলি আসিয়া যথাযথ স্টেপ গ্রহণ না করা থাকায় আমি উত্তর আমক্তনামা দাতা হিসেবে চিন্তা করিয়া এবং আমার আত্মীয় স্বজন বন্ধু বান্ধব ও অন্যান্য আত্মীয় স্বজন সর্বোপরি আমার আইনজ্ঞের সহিত সবিশেষ আলোচনা করিয়া আমার পিতা শঙ্কর মাইতি পিতা দাসপুর থানা উত্তর আমক্তনামার পক্ষে আমার পক্ষে তরফে আমক্তনামা করিয়া স্বীকার অঙ্গীকার ও ঘোষণা পরীক্ষা করিয়া আসিতেছি। হোয়ার মাই লর্ড রাজ্যের বাইরে বসবাস করিয়া হোয়ার হিজ ইজ স্টেটেড at present where it is residing, my lord, it has not been stated that particularly. So there's a divide of particulars of his residence and all these things. This is completely evasive and eludative of the principles of law.
Yes. Anything more?
No, my lord. If you like.
Lord,
Yes.
first on the facts, my lord. My learned friend's client, learned esteemed senior friend's client institutes a suit. I enter appearance. Now I means the son through his father enters appearance and my lord files a written statement and written objection to the injunction application. Now thereafter, when I realize that there is some irregularity in the power of attorney executed by the son in favor of the father, a subsequent power of attorney, that is a regularized one, was filed before the learned trial court. Kindly seize the order impugned. My lord would kindly take the second paragraph of the order impugned.
13th of March.
13th of March. The learned advocate on behalf of the defendant side submits that before this court that the general power of attorney in this suit was given by the son to his father because of the fact that the son mostly stays outside the learned advocate. Further submits that irregularity regarding the general power of attorney on account of that fact that no notarization was done cannot be, it's meets written, but it should be B, that the document is not valid and cannot result in striking of the defense in any way. The plaintiff side has never disputed the signature of the defendant number 1. Now, with regard to the question whether irregular power of attorney can be rectified or not, the learned advocate on behalf of the defendant side submits that to cure such defect, one subsequent power of attorney was filed on 18/1/2025. The learned advocate then refers to one ruling, that is the judgment placed by my learned senior friend, wherein the Honorable Apex Court held that in case where there is initially a defective power of attorney and sale took place on the basis of a defective power of attorney and the seller subsequently made one fresh power of attorney correcting such defect, it was held to be a valid sale and its registration thereof. Furthermore, the learned advocate for the defendant refers to para 8 and 10 of the ruling, being Graphitech International versus KK Kaura and others, decided on 3rd January 2002, wherein the Honorable Delhi High Court in para 10 of the said judgment had categorically observed in crystal clear terms that the importance of power of attorney without notarization cannot be undermined, but at the same time, if such a defect is removed subsequently during the pendency of the suit, that too is followed by ratification of the authority of a person who has been authorized to institute the suit, it is not such a fatal infirmity that would hit the maintainability of the suit itself. So this case, which was referred by my client before the learned trial court, relates to the plaintiff. Here I am the defendant. Now your lordship would kindly take, first, the signature has not been disputed. Is it my learned senior friend's case that the signature is being disputed? Nowhere in the four corners of the application that starts at page 17, he has not made out a case that the signature is being disputed. There are certain infirmities, yes. And whenever I realize that infirmity on 18/1/2025, I cure that. I file a fresh power of attorney. And another fact, my lord, that is not available in the records of this order impugned, but I had checked it from the learned trial court's advocate that another set of written statement and written objection was filed. That was kept on record on 18/1/2025.
My lord, I am saying that Lord Counsel, he has not completed. He has not completed.
On 18/1/2025, I file a fresh power of attorney. And most importantly, it is not my learned senior friend's case that he is disputing the signature. He is disputing the authority. That's not the case.
Fresh power of attorney has been filed on
18/1/2025.
18/1/2025.
It is available from the order impugned itself. My lord would kindly say I read it before, lordship. May I just again? Second paragraph.
Yes, 18/1/2025.
On 18, this was filed. Therefore, the court, after going through these numerous decisions, holds that this is mere a procedural defect and this can be cured. Now, to this, my lord, I will rely on certain authorities. First, my lord, I will be relying on a 3 judges bench judgment of the Honorable Supreme Court, 2006, Volume 1, Supreme Court Cases, page 75. The paragraph 15, I will be relying. 2006, Volume 1, Supreme Court Cases, page 75. 6-1. 1. 75. My lord would kindly take paragraph 15.
We can come back after recess. Learned Counsel, Learned Senior Counsel, we can come back after recess at 2 p.m. It will continue.
Right. May I have that judgment, man? I'll make a photocopy, my lord.
It will continue after recess.
Just to recapitulate, initially I filed a power of attorney that is admittedly defective.
Not having identified by anybody.
Subsequently, I filed on January 2025. The court takes note of that and says that since it's merely procedural and my learned friend's client will not be prejudiced and the signature has not been disputed, therefore the court in a way pardons me, cures the defect because it's a procedural. Now to this, my lord, I was relying on a judgment of the Honorable Supreme Court, 2006, Volume 1, Supreme Court Cases, page 75. May I first place paragraph 15 and then It is, my lord has found paragraph 15. It is thus now well settled that any defect in signing the memorandum of appeal or any defect in the authority of the person signing the memorandum of appeal or omission to file the wakalatnama executed by the appellant along with the appeal will not invalidate the memorandum of appeal if such omission or defect is not deliberate. Thereafter, my lord, kindly takes the fundamental law that has been laid down at paragraph 17. This was a case of memorandum of appeal, defective memorandum of appeal. Kindly takes paragraph 17. Non-compliance with any procedural requirement relating to a pleading, memorandum of appeal, or application or petition for relief should not entail automatic dismissal or rejection unless the relevant statute or rule so mandates. Procedural defects and irregularities which are curable should not be allowed to defeat substantive rights or to cause injustice. Procedure, a handmaiden to justice, should never be a tool to deny justice or perpetuate injustice by any oppressive or punitive use. Here my substantial right is the right to contest the suit. The plaintiff is not disputing the signature. Therefore, how is my learned senior friend's client being prejudiced? One. And two, my lord, this if I'm not allowed, then my substantive right will be defeated. And it is not that I have not cured my defect. I have cured my defect. That is evident from the order impugned herein. Thereafter, my lord, the learned court has relied on a judgment that has also been reported. Graphitech International versus KK Kauda. My lord will find in the order impugned. This is the SCC online. I have got it from SCC online. My lord would kindly.
Corresponding to SCC online.
My lord, SCC online. It was reported in 2002. Dell SCC online Dell 3. 2002 SCC online Dell 3.
Copy দেবে
আচ্ছা আমি আমারটাই দিয়ে দিচ্ছি Your lordship would kindly take paragraph 9. First 8 and 9. Well, first place 8. 8. In the instant case, the crucial question that requires to be determined is whether Mr. Such and Such has been authorized to file and institute the suit or not. The very fact that actions of Mr. Such and Such were ratified by way of fresh power of attorney, which was duly notarized, shows that the earlier power of attorney was in order, but for its notarization. Therefore, thereafter, merely because the power of attorney is not notarized does not mean that the concerned person was not authorized to institute the suit. Notarization raises presumption as to the authentication and no more. Notarization of power of attorney is a matter of procedure and raises the presumption of authority of the person to institute the suit. In other words, it does not mean that the power of attorney executed in favor of a particular person but not duly notarized does not confer power upon the person to institute the suit. The objection taken by the learned counsel is that the power of attorney does not bear any authentication by a notary public, and therefore Mr. Mago and had no authority to file the present suit, and as a consequence, such a suit was never properly instituted. The importance of power of attorney without notarization cannot be undermined, but at the same time, if such a defect is removed subsequently during the pendency of the suit, and that too is followed by a ratification of the authority of a person who has been authorized to institute the suit, it is not such a fatal infirmity that would hit at the maintainability of the suit itself. Here it was a question of notarization, but in my case, my lord, neither there was notarization nor there was identification. But as regards notarization, it is not fatal. Even if it is not notarized, it's not fatal. Next, it has been vehemently argued by my learned senior friend that section 85. My lord, my humble submission before your lordship is section 85 has no bearing in this instant proceeding. Why? What does section 85 say? Section 85 says, raises a presumption of a notarized power of attorney. Here my case was, the case before the admitted case, that there was no notarized power of attorney at the first instance. Thereafter, my lord, when I realized this irregularity, a fresh power of attorney was executed and that has been filed before the learned court. That the court takes cognizance. Therefore, section 85 has no bearing in this case at this stage. And lastly, my lord, since the signature is not being disputed, well, it's merely a procedural defect, and this can be cured and has rightly been cured by the learned court. And that's all.
Yes, Lord.
Firstly, Lordship kindly start with my 151 application. Page 18, paragraph 4, my lord. It shall state that the general power of attorney, defendant number 1, has been mentioned that he is living outside the state of West Bengal for his business, while no address has been mentioned, disclosed where he presently living address. As such, signature on his said power of attorney is not executed by the defendant number 1. As such, it is very much mischievous and practicing fraud upon the court of law. And I also challenge this signature by the genuine person or the defendant number 1. That your petitioner says the general power of attorney was signed on 18/11/23 on behalf of the defendant number 1, but the same was drafted by the learned advocate Parthabatim Datta West Bengal Bar Council number, putting signature on his hand on 18/12/23. 18/12/23 is the said difference, which is very much gross irregularity and absurdity. My lord, he signed on, my lord, sign on 18/11/23, and the lawyer who signed his signature on 18/12, just after month. My lord, got it?
Yes.
My lord, My lord, the page 19, internal page 3, my lord. Paragraph 18, paragraph 19, paragraph 7, about Aadhaar. That Aadhaar card to come that the petitioner state that the power of attorney did not mention the place of signature of the defendant number one. If the defendant number one is not living in the village Alipur Post PS Daspur, district Paschim Medinipur, has been proved by the Post Department and also bailiff of the court, London court, as such the general property was not only authenticated by the deponent and not attached the identity proved by the Aadhaar card. Or not even the Aadhaar card was produced before the court of law. Paragraph 8, method. That your petitioner said that in the present general power of attorney, no advocate has identified the deponent's signature. As such, it is very much doubtful and false to the knowledge of the deponent and falsification before the court of law. Paragraph 19. Petitioner states that paragraph 9, that the petitioner states that the Bhogaradama was filed by the defendant number one on 17th October 2023, was not signed and authenticated by the defendant number one, as there are some other signature is thereon. Why not kindly look into this power of attorney?
Lord Counsel, you are replying, not your submission has been completed.
My lord.
You are replying
Yeah.
only on the law point.
My lord, firstly, the no objection of my 151 before the trial court. No written objection has been filed by the London friend. Secondly, my lord, the court and one London has argued.
What have you submitted?
Hello?
The court couldn't get. What have you submitted just now?
No objection has been filed against. No objection. The objection are challenged by way of 151 application before the London trial court. No objection has been filed against this 151 application. Am I clear? Secondly, my lord, this my lord, London friend as well as the London court, my lord, misleading the procedure which is covered and governed by the civil procedure code. Well, civil procedure code, you cannot file the objection and the written statement beyond the period of beyond the 90 days by the West Bengal Amendment Act. Provided further that the court can accept some cases, extend time beyond the
Lord Counsel, which order you are challenging?
order 8, my lord.
No. Which order you are challenging? The impugned order?
Impugned order, my lord. Order number 13, page, my lord. 13 March 23. 25, my lord. Joseph. My lord, the civil procedure code order 8, 1 written statement.
Lord Counsel, we are not concerned with 30 days or 90 days now. In this through this impugned order, we are not concerned with
Because
30 days
by
or 90
allowing
days.
the defendant number one to file the written statement.
It was filed earlier.
No. By that has been defective. If the fraudulent one was in time in everything, but the second set of by curing the defect after 2 years, well, that cannot be allowed in view of the order 8 rule 1, because the 90 days is the time. The order number 11 today is fixed for hearing under order 51 and the written objection no meantime extended. Plaintiff contesting defendant 1 and 2 file Hajira through prospective. Are considered the prayer is allowed That interjection is dependent number 1 and written objection supported by the affidavit. This came to its record, also file power of attorney and file praying for accepting the same prayer is allowed. It appears from the record that one petition dated 4/4 is pending.
When is filed?
Well, the second written objection and the written statement was filed on 18 January 2005. Just after 2 years, which cannot be allowed by the procedural law under Order 8 Rule 1. 90 days you have to file the written statement. My lord, got it?
What were your prayers to the Acha.
Civil procedural do the same.
Yes.
My lord, got didn't.
No, I have it.
It is an old settled principle, my lord.
Yes.
90 days to the statement to be filed.
Mhm.
By virtue of by order, as well as in London Federal State, that this provision also became nugatory. You cannot file beyond the 90 days.
Yes.
If one is defective, the second one cannot be accepted because it's beyond 90 days. And the 151 applications, no objection has been filed by the London Friend's client.
Yes.
So this in order cannot stand in view of this clear mandatory provision of the section 84 of the Bharatiya Sakya Abhidhanam.
ভারতীয় সাক্ষ্য অধিনিয়ম.
Odhiniyam, my lord. Our old evidence, we are habituated for more than 50 years. Why it is necessary for the law ministry this?
Anything more, learned counsel?
My lord. That's the pull up. The statement has been filed after 2 years, which cannot. The court has no power. Court is the creature of the statute. Court has no power to extend the time beyond the period has it prescribed by this procedural law of the civil procedure code, which is arbitrary and nugatory on the part of the statute, which court cannot do so. It has the jurisdiction to do so. I think that is it.
No, I'm not replying. Today.
The learned counsel representing the petitioner submits that this impugned order, through the impugned order, the learned trial judge, after considering the submissions of both the sides, had rejected the application filed under section 151 of the Code of Civil Procedure, through which the written statement and the written objection of the defendant number 1 was prayed to be rejected, and had also prayed for ex parte hearing of the suit. Full stop. The learned counsel, learned senior counsel, representing the petitioners, has further submitted that in the power of attorney, which was filed earlier, the said power of attorney did not have the signature of any learned advocate identifying Sri Anjan Maiti
And also,
Who was the-
original number.
who was the-
Oh, it is this thing, a forward is only the Xerox copy, photocopy, my lord. Original has not been filed. Before the, it has not been filed.
Wherein it is mentioned that only the photocopy has been filed, the original has not been filed?
Yes, my lord. In my 151 application.
No. In the order, in the ordering portion or in the impugned order, where it has been mentioned?
I don't know that. Madam, Alexa, page 11, madam. Yes,
No,
the current put up for the date, depending on file, this day, a photocopy of the Amoktar Nama be kept on record. Copy, my lord got it.
Page 11, ordered dated
Dated 20 December 2023. Dependent number 1 files the written objection and the written objection this day with a photocopy of Amoktar Nama. Let this be kept on the copy, sir. Madam got it?
Who was appointed as a constituted attorney by his son, that is Shankar no, it's not the Shankar Mighty. Okay. Sentence last sentence. Identifying Onion Mighty. Who had appointed through the said power of attorney his father, namely Sri Shankar Mighty. Paragraph. The learned counsel has further submitted that has relied upon section 85 of the Indian Evidence Act 1872 corresponding to section 84 of the Bharatiya Shakya Adhiniyam and has submitted that the court shall presume that every document purporting to be a power of attorney, comma, and to have been executed before, comma, and authenticated by, comma, a notary public or any court, comma, judge, comma, magistrate, Indian counsel or vice counsel or representative of the central government, comma, was so executed and authenticated. The learned counsel has further submitted that through the application under section 151 of the Code of Civil Procedure, the plaintiff petitioner had sought for rejection of the written statement not accepting, had also prayed for not accepting the written statement. Full stop. He has further submitted that the written statement which has been subsequently filed, that is on, when have we filed the second written
January
statement?
18, 2025.
18th January 2025 is beyond the statutory period as has been laid down under Order 8, Rule 1 of the Code of Civil Procedure. Full stop. He has further while in support of his contention, the learned counsel has relied upon an authority published in 1970, Volume 2, SCC, page 386, corresponding to AIR 1971, Supreme Court, page 761, and has relied upon. You have later on provided the hard copy, no? No, you have provided the
I
hard
had
copy.
provided. I had submitted the SCC online.
And has relied upon the fact that the presentation for registration could be either by the principal or by a duly constituted attorney, and has further submitted that it is equally plain that a proper power of attorney duly authenticated as required by law had to be made before power could be conferred on another, either to execute the document or to present it for registration. Full stop. Banking upon the aforesaid submission, the learned senior counsel has submitted that the impugned order passed by the learned civil judge senior division Ghatal.
Yes, ma'am.
Civil judge senior division Ghatal is liable to be set aside. Full stop. Paragraph. On the contrary, the learned counsel representing the opposite party has submitted that the signature of the signature of Onjon Maiti has not been challenged. Only the identification by a learned advocate being not there in the power of attorney, it has been challenged, and subsequently on recognizing that the first power of attorney being not in regular form has subsequently filed another power of attorney dated 18/1/2025, 18/1/2025, thereby rectifying the procedural lapses. In support of his contention, the learned counsel has relied upon two authorities published at 2006, one SCC, page 75, and the other being 2002 SCC Online, Delhi, page 3. Corresponding to 2002 bracket is 62 DRJ, Delhi reported judgments, full form likhte hobe na, page 72. Full stop. Relying upon the learned counsel has placed paragraph 15 and paragraph 17 of the judgment of the Honorable Apex Court, wherein it has been stated that it is now well settled that any defect in signing the memorandum of appeal or any defect in the authority of the person signing the memorandum of appeal, comma, or the omission to file the wakalatnama, or the omission to file the wakalatnama executed by the appellant, comma, along with the appeal, comma, will not invalidate the memorandum of appeal, comma, if such omission or defect is not deliberate and the signing of the memorandum of appeal or the presentation thereof before the appellate court was within the knowledge and authority of the appellant. He has further relied upon paragraph 17 of the said judgment, wherein it has been mentioned that non-compliance with any procedural requirement relating to a pleading, comma, memorandum of appeal or application or petition for relief should not entail automatic dismissal or rejection, comma, unless the relevant statute or rule so mandates. Procedural defects and irregularities which are curable should not be allowed to defeat substantive rights or to cause injustice. Full stop. Procedure, comma, a handmaiden to justice, comma, should never be made a tool to deny justice or perpetual injustice, comma, by any oppressive or punitive use. Full stop. The learned counsel has relied upon paragraphs 8, 9, and 10 of the judgment published in 2002, bracket 62, Delhi reported judgments, page 72. And has submitted that to the said paragraphs, the question that has been raised to be determined is whether Mr. Ravi K. Magon, paragraph 8, paragraph 8, paragraph 9, notarization raises presumption as to authentication and no more, or paragraph 10, the importance of power of attorney without notarization cannot be undermined but at the same time, if such a defect is removed subsequently during the pendency of the suit, and that too is followed by ratification of the authority of a person who has been authorized to institute the suit, it is not such a fatal infirmity that would hit at the maintainability of the suit itself. Full stop. Paragraph. On consideration of submission of learned counsels and on perusal of the authorities filed on behalf of the petitioner and on behalf of the opposite party, it transpires that non-compliance with any procedural requirement relating to a pleading from a memorandum of appeal or application or petition for relief should not entail automatic dismissal or rejection, which has been laid down by the Honorable Apex Court in the judgment published in the judgment passed in the case between Uday Shankar TRIYAR versus Ram Kalevar Prasad Singh and another. It is also fact that in the present list, subsequently on 18/1/2025, another power of attorney was filed rectifying the procedural defects, and in support and in addition to the said power of attorney, a written statement was also filed. This subsequent rectification of the procedural defect has been considered by the learned trial court and has come to the finding that the prayer sought for through the application under section 151 of the Code of Civil Procedure is liable to be rejected. This court is at one with the view of the learned trial judge as to the fact that the son who had authorized his father to a power of attorney earlier has once again rectified the procedural defects which were present in the first power of attorney by filing a subsequent power of attorney. In such circumstance, it is presumed that the earlier power of attorney was executed by the son, namely Anjan Maiti, in favor of his father, namely Shankar Maiti. This gives an effect that the earlier power of attorney, which had some procedural defects, was executed by the son in favor of his father, and accordingly the constituted attorney had taken steps in the present list. In such circumstance, the impugned order, this court is of the view that by accepting the written statement filed by the defendant and rejecting the application filed under section 151 of the Code of Civil Procedure by the trial judge does not require interference. As such, the present revisional application is rejected. Sorry.
No, it's not. It's a part of the games.
Next.
Item number 22.
Lordship, in this matter, I am for the petitioner. Lordship, the talks of settlements are.
Yes.
Lordship, in this matter, I am for the petitioner.
Hmm.
Lordship, the talks of settlement are going on. So, Lordship, in that regard, I am praying for not this week. Kindly fix the matter on next month.
Learned Counsel, this matter first appeared on 12th of August 2026.
Lordship.
On that day, an accommodation was sought for on the ground of personal inconvenience of the advocate on record.
Lordship.
Thereafter, the matter appeared once again on 14th of seeks an accommodation for this day, that is on 12th of August 2026. Thereafter, on 14th of August, none had represented the petitioner. Now, after about fortnight, you are coming up with the issue that settlement is going on. It is hard to believe, Learned Counsel.
Lordship, kindly.
Settlement had proceeded, then it should have been done in the meantime. It ought to have taken place within 12th to 27th. 15 days is a long enough time.
Lordship, then kindly grant me an accommodation. My senior will move it before you on the next date. Kindly grant me an accommodation. Actually, I have been instructed by the client, so I'm.
Are you the advocate on record?
No, Your Lordship. My
Who is the
senior
advocate on record?
Mr. Anirban Roy.
On the first day, on his ground, the matter had been considered and accommodation was provided. On the second day, nobody represented, neither the advocate on record, any advocate represented the petitioners. And today the learned advocate on record is also not there. Nil. On going through the order sheets, it transpires that on 12th of August 2026, an accommodation was sought for on the ground of the learned advocate on record. And on 14th of August 2026, none had represented the petitioners. And just today, learned advocate representing the petitioners has submitted that a talk of settlement is going on. Talk of settlement is going on. Considered the submission of the learned counsel. And also considering the previous orders, let the matter appear on 22nd of September as last chance. On that day, if as last chance, London Council, 22nd of September.
item number 12.
22 হয়ে গেছে 22 কি হয়ে গেল
For the petitioner, defendant petitioner. Your lordship heard this matter on the last previous occasion, my lord, for about 2 or 3 days, but the matter could not be heard finally.
and learned counsel on
Initially, my lord, this revisional application has been
on
preferred.
30th of January, on consent of both sides, the parties, on consent of both the parties, let the matter appear on 6th of February. Thereafter, on 11th of August, none
Nothing,
represented.
Today, he is not also here. I do not know, my lord. But,
Has the copy of the revisional application?
yes, copy has been served, he appeared.
Hmm.
Now, whether I will inform him once again to the learned advocate, otherwise we will again come and,
Nil.
and my lord, only one thing, I will inform you.
As none is representing the opposite party, the learned counsel representing the petitioner has been candid enough to submit that he intends to intimate the learned counsel representing the opposite party. Consider the submission of the learned counsel. Let the paragraph, let the learned counsel representing the opposite party be intimated as regards to the next date of hearing. Full stop. Accordingly, let the matter appear on
Your lordship, middle of September.
Hmm?
Next week, I have some cases before the land tribunal, that is.
let the matter appear on 22nd of September.
My lord.
And to file an affidavit in this regard. Serve upon the opposite party, learned counsel representing the opposite party. And file an affidavit. Next.
Number 23.
My lord, your lordship again and again directed us to serve copies or notice. And 2 sets of lawyers. One now has come. My lord, your lordship on the last occasion also again directed to give a notice in terms of your lordship order on 17th August.
$17.
My lord, here is the affidavit of service and they have no appeal. And another set also reported me, but I told them already one set has appeared. Now, my lord, let me place the.
You are representing the state.
Yes, my lord.
So now the state is being represented.
No, yes, that is right.
এটা আচ্ছা ঠিক আছে পরে হবে affidavit এখানে রেখে দিন এখানে থাক yes
My lord-
section 8 West Bengal Land Reforms Act
No, this is land
My lord,
acquisition.
Pursuant to this, my lord, this is a recalling application. Now they are stating in the application that
let
one
them
wrong
submit
submission has been made and that's why application needs to be recorded. This is
let
the
them
biggest
submit
settlement.
let them settled matter is settled
My lord, so far as we as state is concerned, my lord, entire payment has been made. This is arising out of acquisition. Payment has been made, my lord. Now first they have to cross the hurdle of
Kindly ask him to show.
let us not
Nothing, my lord.
let
This
us
is a
not
recording
argue
application. Let
Why?
them cross the
Let us
hurdle, my
not
lord.
argue.
Execution case is still pending.
let us not argue let us
properly.
hear the matter
My lord,
Cross the hurdle, we will answer.
My lord, your lordship will remember, this is an application for recalling. This is not the motion. We filed a civil revision application.
this application
No, the application, the order which has been sought for modification by way of this application for recalling.
That is, that is why, my lord, I am placing first what happened, series of facts.
No, Mr. Mukherjee, the order which you are seeking to be recalled,
Yes.
that was not passed in this revisional application. That was passed in
No,
another
no,
revisional application.
this is in this revision.
In this revisional, yes.
There, my lord, I am just giving the
Order.
This is I am giving, my lord, the order dated an application for recalling the order dated 27 July 2023. In the cost title itself, my lord, in the cost title, yes, turn to page.
So we are taking up a can.
Page, yes, page 18.
One minute.
We'll turn
One
to
minute.
page 18.
Let us first go to the trace out the
Order.
order.
Yes, my lord, order this pursuant to the service of the administrative notice upon the parties, Mr. Shakti Prasad Chakraborty, Learned Counsel, representing the petitioner, Mrs. Texmaco Limited submits before the court that the petitioner has received all its dues and revisional application has lost its relevance.
Let the order be traced.
Page 18, my lord.
One minute. No,
Can
on the order sheet, let the order be traced first.
Order of Siddhartha Rai Chaudhary.
Oh, 27th July 2023.
My lord.
A short order.
This is
Pursuant to the service.
nothing. Well, what happened? First of all, your lordship will have to know.
Pursuant to the service of administrative notice upon the parties, Mr. Shakti Prasad Chakraborty, Learned Counsel, representing the petitioner, Mrs. Texmaco Limited submits before the court that the petitioner has received all its dues and the revisional application has lost its relevance. Under such circumstance, the petition is disposed of being infructuous.
Everything is okay and that should be there. One wrong submission that was done by the learned advocate. Under what circumstance I am stating that there is no dues line. Now I submit before lordship. First of all, this revisional application was filed.
So, as far as the court can get, there's an allegation against a learned counsel.
No, he has also, that is why a supplementary affidavit has also been filed with the leave of the court. The court has granted leave to my lord, kindly take the supplementary affidavit. 8th April 2026, pursuant to the leave granted by successive two honorable judge of this court. Firstly, ওই একটা দাও বিভাস চৌধুরী
কেন সামনে থাকছে অ্যাফিডেভিট এবং সার্ভিসগুলো পেছনে চলে যাবে
বিভাস চৌধুরী যেটা
তার আগে supplementary affidavit on behalf of the petitioner.
Yes,
dated
this is my lord. First of all, ওইটা দাও তুমি ওই এটা বিভাস চৌধুরী এর আগেরটা
8th of April 2026. Supplementary affidavit?
No. Yes. Before that, a supplementary affidavit was already prepared. Unfortunately, it was misplaced because this was not the regular bench when it is coming. Anyway, my lord, kindly have your lordship got it?
Yes, page.
Now, my lord, I am reading this is the learned advocate Shakti Prasad Chakraborty, page 5, who was the advocate on record in this matter.
Page 5.
Yes. Well, this is the advocate's letter, which is annexure.
Page 6.
P1. Yes, 6. Page 5.
No, page 5 is the affidavit portion, last page of the application.
All right.
Page 6.
Yes. Well, I am reading it. This is to inform you that the above referred revision application filed by your company, actually company to Ashok Kumar Bijay, Executive Director Finance, Texmaco Infrastructure. They sought for the explanation why you have said this. This is to inform you that the above referred revision application filed by your company by challenging the order dated 4th September 2014 passed by the learned LA Judge Third Court at Barasat. My lord has got it.
Yes, sir.
Not 24 was in contention with LRA execution number 01 of 2012 arising out of LRA case number 18 of 2002, where I was engaged as an advocate on record. This instant issue has already resolved by the Honorable Supreme Court of India with the order dated 13th December 2017. Since from the order dated 25th November 2014, this revision application being CO number 3112 of 2014 has been pending before this honorable court at Calcutta, and suddenly this matter came up for hearing before His Lordship, the Honorable Justice Siddhartha Rai Chaudhary on 27th July 2023. Well, kindly mark it. This was pending since 2014. Practically, they are not appearing, challenging certain order. The order is practically in an execution case, is still pending. There, the PR account, public, well, not PLA account, public ledgers account, from which the Barasat, it was attached. And after that, the learned GP at that time made an application before the executing court for vacating that PLI account. But he immediately vacated without assigning any reason. Because of the dues, this was attached. So that was challenged by this revisional application. And now if your lordship turn to the revisional application itself, the orders are very clear. Any order to go? Well, kindly turn to Annexure P1, page 10, 25th September 2014. Can 1.
You are referring to Can 1, not the application.
Can 1.
Referring to Can 1.
Can 1. That we have narrated the entire thing. Because that application has already been disposed of, original civil division.
Can 1, page?
Page 10.
Yes, page 10.
Well, it has got it. There is no justification on the part of the state there is no justification on the part of the state to not pay the compensation due to the petitioner immediately, particularly since the state has failed to honor the condition imposed by a division bench of this court to deposit a part of payment for the stay of the operation of the award to continue. The appeal may be pending, but there is no subsisting order staying the operation of the award. Indeed, the default clause in the division bench order permits the award to be executed. The executing court had appropriately passed, passed an order on July 4, 2014, attaching PL account 8443 of the collector, North 24 Parganas, lying with the State Bank of India, Barasat branch, relating to Barasat Treasury 1, North 24 Parganas. Despite the state as judgment debtor not paying a penny to the degree holder, the executing court recalled its order of July 4, 2014 on an application filed by the state. My lord has now, I believe the lordship will understand what I want to. Despite the state as judgment debtor not paying a penny to the degree holder, the executing court recalled its order dated 4th July 2014 by which PLA account was attached by the executing court on an application filed by the state. It is the order of September 4, 2014 passed on the state's recalling application that is challenged here. Since it appears the order impugned is ex facie without basis and irregular exercise of jurisdiction, such order is liable to be set aside for the asking. The state cannot be treated as a favored litigant. Advocate for the state seeks an adjournment. That appears to be most meritorious submission on behalf of the state in the matter. The matter is adjourned till September 29, 2004, unless an amount of rupees 25 crore is paid to the petitioner before the matter is taken up. The state's request for further time may not be acceded to. The petitioner's claim is, however, for an amount of in excess of 40 crores. This is the recording of Justice Sanjeev Banerjee as his lordship on 25th September 2014. It will be open to the state to carry banker's check or like instrument not being check issued by the state when the matter appears next on September 29, 2014. The relevant instrument should be made out in favor of the degree holder and the payment will be subject to the result of the state's appeal from the award. Urgent certified copy. Next. Well, on 25th November 2014, next order by the Honorable Court at that time. A further payment of 4,46 crore, 4.46 crore has been tendered by way of banker's check by the state to the petitioner in court today. Upon encashment of the relevant instrument, a total sum of, it is the finding of the Honorable Judge, total sum of about 10 crore 26 lakhs would have been paid by the state to the petitioner hearing. Let the matter now appear 6 weeks hence. The PL account number such and such of the collector, not 24 Parganas, maintained with the State Bank of India, Barasat branch, relating to Barasat Treasury 1, not 24 Parganas, as attached by the order of September 29, 2014, stands vacated with immediate effect. That means upon depositing of that 4.46 crores, the Honorable Court was pleased to vacate. Because nothing was being paid, court found that 40 crore is already due. Next. In fact, by this time, the matter went before the division bench, not with that original award that is pending for execution before the tribunal. I mean collector, additional district judge. There, my lord, the judgment was passed by Jyotirmoy Bhattacharya and Honorable Justice Ishan Chandra Das. State of West Bengal versus Texmaco. Am I correct, my lord? The judgment was delivered, kindly note the date, 18th day of November 2016. Page 14. My lord, sir, got it? Yes. It is next page. It is ordered and decreed that the appeal be and the same is hereby allowed by modifying the degree of the learned land acquisition judge to the following extent. The valuation of the solid land be hereby fixed at 1,04,406 per kata. The valuation of tank and dover to be fixed 50,203 per kata. The referent claimants, my client, oblique cross objectors in that appeal, state preferred the appeal, we were the cross objector. Be entitled to get solicium 30% on the entire market value. The referent claimant, oblique cross objector, be entitled to get additional compensation as this matter was done. Finally, it is further ordered and decreed that the claimant cross objector shall and do withdraw the balance amount which is still deposited with the bank. It is further ordered and decreed the learned registrars and do encash the fixed deposit and shall do and pay the same to the referring claimant's cross obligation, that means my client, Texmaco, subject to compliance of the necessary formalities by the referring claim cross objectors. So this is the division bench order. Against that, state again moved the Honorable Supreme Court. Kindly mark it, page 16. Yes. The special leave petition is accordingly dismissed. That was the date
on 13th December, my lord, 2017. And we are, my lord, talking about the order of 2014. So it has been modified and that has been confirmed by the division bench by this time, by enhancement and all these things. And against that, state preferred an SLP before the Honorable Apex Court. That was also rejected. And by this time, my lord, the purpose. By this time, the purpose has been served in the sense because PLA account, which was, my lord, the execution court actually attached, that has been vacated by depositing 4 crores. Court directive, out of 40, you must bring 25. However, Honorable Court considered it upon depositing 4 point something odd crores. Yes, by depositing, court, my lord, vacated the order. So matter goes there. Either it could have been disposed of, or naturally lawyer also did not attend regularly. Ultimately, the matter certainly appeared before Justice Siddhartha Raichudhuri, as his lordship then was. Now nobody appeared, so his lordship directed to give administrative notice. And administrative notice has gone, and court automatically inquired, what about the case? What you say? No, everything has without any instruction. And he had not even gone through the order and result. Ultimately, the court actually passed that order, by which, this page 18.
No, what was the explanation of the learned counsel?
For
submitting something.
Supplementary affidavit, that has been,
To the supplementary.
that is in the
affidavit file.
supplementary affidavit.
What was the explanation?
That has given. In the supplementary affidavit, my lord, the learned advocate.
Why he has submitted so?
That is
Not the true fact.
Yes, yes, he has said, he has admitted and stated. I'm saying, since, my lord, kindly read the letter itself by Shakti Prasad Chakraborty, who was the advocate on record. The paragraphs 2, my lord, this since from the order dated 25th November 2014, the revisional application being CO such as has been pending before the Honorable High Court at Calcutta, and suddenly this matter came up for hearing before His Lordship, the Honorable Justice Siddhartha Raichudhuri, on 27th July 2023, and I was appeared on behalf of the company and submit that the revisional application now became infructuous. Practically, it was infructuous.
He has assigned that during hearing a miscommunication made to.
Miscommunication. No, I'm telling, I'm reading the entirety of it. And part in nature, and part payment has already received. Your lordship got it. 4 point something crore has already been deposited. That is the finding of the honorable judge. Now, received by your petitioner out of the total dues, a part payment has already been received by your petitioner out of its total dues. Malad Justice Sanjeev Banerjee recorded that out of 40 crores, 10 crores have already been deposited. During hearing, a miscommunication made to took into the place.
Out of 40 crores, 10 crore
crores.
and 4.5, near
No,
about
no.
4.6 or something.
With yes, 10 crores, with that, including 4 point something crores, that is total 10 crores.
Total 10 crores.
I am again reading, my lord, for your lordship reading, understanding. I am again reading.
No. Which place, which
Yes,
page?
my lord, page Can 1, page 11.
1 minute.
এখানে এত
The
consultation.
matter is adjourned till September, unless an amount of 25 crore is paid.
My lord, I am reading.
40 crore,
The matter is adjourned till September 29, 2014. Unless an amount of rupees 25 crores is paid to the petitioner before the matter is taken up, the state's request for further time may not be acceded to. The petitioner's claim is, however, for an amount of in excess of 40 crores.
40 crore.
So, this is, my lord, of 2014, when division bench already, my lord, passed the judgment. Now, my lord, next page. your lordship will find the same honorable court judge a further payment of
Yes, sir.
rupees 4 point
Upon the encashment of the relevant instrument, a total sum of rupees
10 crore
10
has
crores.
been, yes. So out of more than 40 crores, 10 crores has been done. So practically it is on 14. Suddenly after 4 years, it appeared before the honorable judge.
So according to you, 30
That is
crores,
in 2023.
according to you, 30 crores were remaining to be paid.
Yes, I am not anything more. That is for before the executing court. And your lordship has nothing to do. Only that wrongly submission, oh, all our dues are paid. There should be part dues as paid. Nothing more, nothing, because it has become already infructuous. When he came to learn, company wrote it that how it has been submitted.
Let them submit.
My lord, first of all, subject to correction, my lord. There is a CAN 2 application for condemnation of delay, perhaps that has not been taken.
My lord, we are not pressing. CAN 2 is not required. High Court has inherent power to call its order at any moment. This is the elementary principle of law in the lower court. So where 151 is being applicable, but High Court itself has inherent power, like Criminal Code, my lord, 482.
Now, my lord, first state has not made this application, my lord. This CAN 2 application has been made by the petitioner himself, my lord. I will begin my, kindly takes the CAN 2 application once, my lord. It will not press to me. Now, my lord, may kindly take page 3, paragraph 5 of the CAN 2 application, my lord.
Yes.
That your applicant states that since from the order dated 25th of November 2014, this revisional application being CO number 3112 of 2014 has been lying pending. Later, this matter was taken up for hearing before His Lordship, the Honorable Justice Siddhartha Rai Chaudhuri, on 8th of June 2023 and 15th of June 2023, respectively. When the matter was called up, no appear on behalf of the petitioner, and His Lordship was pleased to adjourn the incident matter further taken up on hearing for 13th of July 2023. This occasion also no one appear on behalf of the either parties, and Lordship pleased to direct the department to issue the administrative notice upon the learned counsel of the parties. The said administrative notice was received by the learned advocate on record, Mr. Shukti Prasad Chakraborty. Upon receipt of the administrative notice, the learned advocate on record was not consulted with your applicant in regard to this revisional application being CO number such and such. Without having proper instruction from your applicant, the learned advocate on record was appeared and submitted wrong submission before this court. Later, learned advocate on record was not intimated this order to your applicant. Hence, your applicant was not aware of this order. Now, kindly see the justification and explanation. Your applicant came to know about this order on 27th of July 2023, madam. Kindly mark this. And this wrong submission on 10th of June 2024, while collecting a status report of this revisional application being CO number such and such for maintaining office file. As soon as knew this order, difficult to, your applicant applied for a certified copy of this order dated 27th of June 2023 for filing this foregoing recalling application. Your applicant states that your applicant has not committed any mistake or error, but his learned advocate was made a wrong submission before this court without having proper instruction from your applicant. Your applicant further submits that the learned advocate on record has not been intimating such order dated 27th of July 2023 to your applicant. Till today, this order came to know by your applicant while collecting a status report of this revisional application being CO number such and such. For maintaining office file on point of your time, your applicant has not been any laches or deliberate delay in filing the recalling application. Sorry, my lord, that would be laches. Here, wrong. I have read it as so, my lord, this is the basic stand of his recalling application. Paragraph 5 onwards, which I have placed before my lords. This is the legs which he is standing upon. Now, my lord, this is the order.
Do you intend to file anything?
My lord, this is, my lord, kindly appreciate and considers, my lord, also the maintainability of the present application, which is the my lord, this is again.
Do you
My
intend to
lord,
file?
if it is at my pleasure of lord, we will file an affidavit, my lord. Because this is on his pleasure that is this application is there, my lord. My lord, basic principle day-to-day explanation has to be there. And my lord, the order.
When can be filed?
My lord, 3 weeks. My lord, one more line, my lord, I will add, and then I will sum up my submission, my lord. The order which he intends to recall, that was made in his presence, not in my presence.
That was made by the learned counsel on behalf of
My
the
lord,
petitioner.
this is an afterthought, that also after 3 years. Now, my lord,
Let us first overcome the can two.
Can two, certainly, my lord.
We
will file our application.
After after hearing the learned counsel on behalf of the petitioner at length, the learned counsel representing the opposite party state, এটা can 2, ঠিক আছে, can 2 of 2024, can 2 of 2024 এর পরিপ্রেক্ষিতে অর্ডারটা হচ্ছে। হ্যাঁ, can 2 of 2024. The learned counsel representing the state submits that he intends to file an affidavit in opposition in this regard and seeks an accommodation for 3 weeks, full stop. Accordingly, Mr. Mukherjee, 1 week. Let the affidavit in opposition. Let the affidavit in opposition be filed
71 days. That is
within 3 weeks after serving copy in advance upon the learned counsel representing the petitioner, full stop. And the learned counsel representing the petitioner may file an affidavit in reply within 1 week thereafter. So, let the matter appear on 29th of September.
Grateful, my lord.
Let the matter.
With my lords.
they will supply me advance copy.
Yes, advance copy.
Yes, my lord.
Number 24.
In this matter, I am appearing for the Board of Work, my lord.
Hearing CSC, opposite party 9.
My lord,
Private respondent.
my lord, আপনি বলছেন?
ওনার নামটা নিয়ে নেবেন, ওনার নামটা নিয়ে নেবেন।
Lordship, may I submit?
Yes.
Lordship, an order will be given to the effect that we have not been served with a copy of the petition.
Neither have we been served with a copy of the application.
Learned counsel, learned advocate representing the petitioner. Petitioner advocate নাম নিয়ে নিয়েছেন, ওই ফোনে বসে নিন। না, নাম নিয়ে নিন। Representing the petitioner seeks an accommodation. Learned counsel accommodation for how many days?
Not this week.
Achha. Seeks an accommodation for this week on the ground of the learned senior. Full stop. At this juncture, the learned advocate representing the state.
Lordship, opposite party 9, CSC.
Representing the opposite party number 9, that is CESC, and the learned advocate representing the opposite party number 11.
না না আমার ভুল হচ্ছে না
এটা ভুল করেছি
কি করবো বলুন কপি নেই
জাস্ট a minute for
Whom you are representing?
I'm representing Kumar Saha, the opposite party. number
Oh,
11. We only have a copy
Lordship,
of the notice, Your Lordship, as per which we.
Lordship, may I submit?
Among both of you,
No, no,
decide.
no.
Among
Lordship,
both of you,
I
you
am-
decide whom you are representing.
Lordship, I am representing CSC. The notice they have given is wrong. In the petition, it is 11, and in the notice, I am 9.
No, in the
I am
in the
respondent number 13, Your Lordship. Sorry, as per the application, we don't have a copy of the application.
learned advocate representing the CSC, that is CSC Limited, that is the opposite party number 11, and Kumar Saha, that is the opposite party number 13, submits. Both of them, they submit that copy of the revisional application has not been served upon them. Learned counsel, when can you serve? The learned advocate representing the petitioner submits that copy of the revisional application will be served within 28th of August 2026 to the learned advocate representing the opposite party number 11 and opposite party number 13. Let the matter appear on 25th of September.
In this matter, I am appealing for the board of work.
Prior to that,
Opposite party number 9 and 10. I am.
you have received the copy. You have received the copy of the revisional application.
Yes, ma'am. Yes, 25th.
25th of September.
Item number 25, oblige your lordship.
Your Lordship, in this matter, appearing on behalf of the petitioner, the arguing counsel Chandrodoy Roy, who was here on the last occasion, is suffering from a cardiac difficulty, Your Lordship. That's why he has not come to the court. I'm just seeking an accommodation for just today. And as per the last order, Your Lordship, we have already served the affidavit in opposition, and I'm ready to file it today. I'm just praying for accommodation for just today.
Lord, your lordship directed to file.
Learned counsel, have you heard the ground?
Yes, I have heard, my lord. One occasion they are saying the senior is elaborated to the as a judges for on the ground praying for time, another for medical ground. Lord, I have no problem. Lord, kindly withdraw the stay. We are suffering from this. Matter can be continued, no problem. The stay should be vacated because when the stay was granted, your lordship for a limited period, the stay should be vacated. Matter can be heard on merit, no issue. Only stay should be vacated.
Just for the day's
No,
accommodation, Your Lordship.
no.
Could be on the
Learned advocate representing the petitioner. Learned advocate representing the petitioners seeks an accommodation on the ground of the learned arguing counsel, stating that the learned arguing counsel is suffering from cardiac problem. Full stop. Paragraph 6 an accommodation for this day. ঠিক আছে? 6 an accommodation for this day. 6 an accommodation. ঠিক আছে? For this day, 6 an accommodation. The learned advocate representing the opposite parties opposes the prayer. Full stop. Considering the ground on which the accommodation has been sought for being cardiac problem, the court is inclined to grant accommodation. Full stop. Paragraph. As this as this bench won't be available, as this paragraph, as this bench won't be available for the coming fortnight because of circuit, let the matter appear on seventeenth of September, full stop, paragraph, if on that day the learned arguing counsel is not capable of submitting, then an alternative arrangement is to be made.
Your Lordship, may I give the affidavit in opposition to be kept on record? We have duly served the other side, Your Lordship, within time.
Affidavit in opposition has been filed after serving. You have received
It is not affidavit in opposition, it is statement of account.
Affidavit in
Your
opposition
Lordship
against the
directed to-
supplementary affidavit on the last.
Both party was directed to file their supplementary on account. I have
Okay.
filed my accounts, you are also filing accounts. You are the petitioner.
Yes, Your Lordship. It was against the supplementary affidavit of the
At this
respondents.
juncture, the learned counsel representing the petitioner seeks an extension of time to file statement of account on
Yes.
behalf of the petitioners. देखिए की दिए हैं?
That is not a statement of accounts. He has given so many medical papers.
Learned counsel.
Your Lordship, I'll take the required instructions.
As per
and make-
direction, the direction should be complied with. Statement of accounts.
Your Lordship, kindly allow us a week's time.
Order talk.
The time for filing statement of account.
Yes.
On behalf of the petitioners is extended. Full stop. Let a copy of the is extended till next date, till returnable date. Extended till the returnable date. Full stop.
Prior service.
Then you dictate.
No.
Let him take your direction. It extended till the returnable date, subject to providing a copy of the same a week in advance to the learned counsel representing the opposite parties.
Much obliged.
So you will have to serve the copy of the statement of account
by 10th September, Your Lordship.
by 10th September.
Grateful, Your Lordship. Deeply obliged.
Number 26.
Well, in this matter, I am for the opposite parties.
On my affidavit of service, madam.
Affidavit of service এখানে লিখে দেবেন বুঝেছো? কারণ ওটা ওনার চোখে পড়ার দরকার যিনি নেবেন।
My lord, I am for the petitioner defendant.
Have you received the copy of the revisional application, learned counsel?
Yes, Mr.
My lord, I have also filed my affidavit of service. I have filed my affidavit of service. My lord, this order is basically challenging the rejection of my order 7 rule 11 application before the learned trial court, my lord. My lord, the issue is
On which ground you had sought for order rejection of the plaint?
My lord, the issue was that the issue pertains to an open car parking space, my lord. My lord, there was an agreement to sell which was executed in the year 2011, where I was the party and the seller was one Mr. Srinath Rai. Then in 2013, my lord, the opposite party, the petitioner.
Who are you?
My lord, I am the erstwhile purchaser of the car parking space and the defendant in the suit before the trial.
Erstwhile purchaser of the car
parking
open,
space. my lord.
open car,
Open car park space.
space.
So, my lord, there was an agreement where there was an arbitration clause. Since the possession was handed over to me and the possession is still there with me as on date, my lord, since the locations or the locate of the seller was not traceable, so my lord, we filed an application under the Arbitration Act, and my lord, an arbitrator was appointed. Thereafter, my lord, this award was put into execution, and by virtue of that execution, my lord, the deed of conveyance was executed in my favor, which was executed on 5th of May 2017. Now, my lord, challenging that particular deed of conveyance, which is actually challenging the execution proceedings, my lord, the plaintiff had filed the suit before the trial court. My lord, I challenged those proceedings on the ground of 711 that it is not maintainable, because first, it is arising out of an execution application. Second, no cause of action has been disclosed against me, and third was the point of res judicata. So, my lord, that was rejected by the.
Why res judicata? Why res judicata?
My lord, because this issue has already.
But res judicata has no relevance with Order 7, Rule 11.
But, my lord, this was also a ground taken in my application based on the fact, my lord, that since the car parking space issue, where the right title and interest was there, that has been already.
Counsel, you can take into account either Order 7, Rule 11 or res judicata.
My lord, but my application was under 7 Rule 11, my lord, and I'm before that only. So the only ground in my 711 was that since that car parking space was already conveyed to me by a deed of conveyance, where the learned executing court had appointed a executor who had executed the deed of conveyance in my favor. Therefore, I am the absolute owner, and the plaintiff is not the absolute owner. So, my lord, this was the dispute which was raised by them regarding that particular car parking space in a title suit filed before the Alipur court. So, my lord, my point was, my lord, the meaningful reading of the plaintiff will show that
through the impugned order, what?
My lord, that is at page 51, my lord. Order
Rejected. Order 7, Rule 11 was rejected.
rejected. However, my findings were being recorded in the order.
On which ground it was rejected?
My lord, that is at page 53, the last page of the order. Lord, it starts from that the defendant has also contended that no cause of action has been disclosed in the present suit by the plaintiffs. However, the perusal of the plaint, which is the scope of the scrutiny at this stage, does not indeed disclose a cause of action to be proved by the plaintiff at trial. Also, the plaintiffs are contesting the purported deed of conveyance dated 5th of May 2017 as not binding upon them for being not made as a party to it. The question of res judicata is not palpable at this stage without evidence on board, and result in light of the aforesaid discussion, the prayer under Order 7 Rule 11 CPC fails. Hence, it is ordered that the petition under Order 7 Rule 11 of CPC dated 12 February 2020 filed by the defendant is considered and rejected on contest, but without any order as to cost.
And you have also raised as regards to the cause of action. What about the cause of action?
My lord, the cause of
Where it
action.
has been dealt.
The cause of action is on the prior page of this order. If my lord may kindly take the first page of the order from third paragraph onwards, my lord.
Earlier, what was decided?
My
Why
lord,
you have raised the issue of res judicata?
my lord,
Earlier,
because
what was decided?
earlier the executing court, the Alipur, before the Alipur, executing court, my lord, a deed of conveyance was executed in my favor where the car parking space has been registered in my name and was mutated thereafter. So, my lord, the dates are very important here, but I'll just indicate the dates one. My lord, on 29th of May 2011 is the agreement to sell, which contained an arbitration clause. My lord, thereafter on 23rd of October 2013.
1 minute. Agreement for sale is 29th of May 2011.
Now, my lord, 23rd of August 2013 is the date when the seller had
resell the property to the plaintiffs, the opposite party hearing. That is on 23rd of October 2013. Then, my lord,
23rd October 2013.
my lord, the plaintiff purchased this car parking space along with a flat. And it is there in their plaint. My lord, then the third important date is, my lord, 30th of July 2014, when the award was passed by the Honorable Tribunal.
What the tribunal passed?
My lord,
What order was passed by the tribunal?
But in my favor, that I am entitled to the car parking space. And my lord, on 5th of May 2017, a deed of conveyance was registered in my favor by the learned court itself. My lord, 5th of May 2017.
Yes.
My lord, my humble submission is, my lord, that the meaningful reading of the plaint will show that the opposite party have essentially challenged the order passed by the district judge in an executing proceedings. And they have also challenged the deed of conveyance, which was the outcome of the arbitral execution proceedings, which is deed of conveyance dated May 5th, 2017. And therefore, a suit is not maintainable for challenging the order passed in execution proceedings. As well as the right, title, and interest of the property was already decided in the execution proceedings by the arbitral tribunal, my lord, that issue cannot be raised again. And since no cause of action was disclosed against me, for this reason, we came up with an application under Order 7, Rule 11. And my lord, this was also in the knowledge of the plaintiff itself. If your lordship kindly comes to page 21, paragraph 7, my lord. This is their plaint.
Yes.
My lord, page 21, paragraph 7, my lord. My lord, start that the plaintiff states that on perusing the said documents, they immediately rushed to the corporation, and on coming to know about the illegal ownership of the defendant through a deed executed on 5th May 2017, that the plaintiff states that they immediately rushed to their consulting lawyer, and as per the advice of the learned advocate, obtained a certified copy of a deed of conveyance dated 5th of May 2017. Upon perusal of the said deed, the plaintiff come to know that the defendants by an award passed by the sole arbitrator, Mr. Kajul Dr. Chaudhary, as appointed by him in the arbitration case number so and so, wherein the learned arbitrator awarded for registration of car parking in the name of the defendant. The plaintiff states that subsequently the award passed, the opposite party filed in money execution case number so and so for registration of the deed in favor of the defendant, which is myself, through before the learned district judge at Alipur. The learned district judge at Alipur subsequently transferred the said money execution case to the learned 16 ADJ and get Alipur for disposal. My lord, then paragraph 8. My lord, why I am placing this, my lord, because they had the knowledge of this part, that there is an arbitration proceeding, there was an execution proceedings, and if that disclosed in the plaint itself, my lord, because while exercising the principles under Order 7 or 11, it is only the plaint which has to be considered, and my lord, it is their own admission in the plaint. If your lordship kindly takes paragraph 8 again, that the plaintiff states that the learned 16th ADJ at Alipur, however, allowed the prayer of the defendant, and through the court officer executed the alleged deed of conveyance dated 5th of May 2017 in favor of the defendant. The plaintiff states that on coming to know about the mutation as done by the defendant behind the back of the plaintiff, they henceforth submitted the complaint before the office of the KMC for necessary action against the said mischievous act of the defendant. The KMC authority, however, served notice upon both the parties, and after hearing of both sides, the Municipal Commissioner of Kolkata Municipal Corporation was pleased to cancel the mutation. Now, my lord, paragraph 9. It is a clear-cut admission by them, that the plaintiff states that upon perusal of the material on the records of the money execution case number so and so, as well as the deed of conveyance, came to learn that the defendant had suppressed all the material facts before the arbitrator, as also before the court, also having the full knowledge of the execution and in registration of the deed of conveyance in favor of the plaintiffs in the year 2013 on 23rd October by Srinath Rai and Aarti Rai, the owners of the Schedule A suit property. So, my lord, this Srinath Rai sold me by virtue of an agreement to sell, my lord. He had given me the possession of the property, had took the money, and my lord fled away. My lord, since he was not traceable, therefore I executed the arbitration clause, and an arbitrator was appointed. And thereafter, my lord, I put that award into execution, and by virtue of that execution, my lord, the representative of the learned court below, my lord, had executed a deed of conveyance in my favor, and which is also a superior court. So, my lord, my ground was on 7/11 was that since this issue has already been decided and no cause of action has been disclosed against me, therefore this plaint is not maintained. And I have a prior title by virtue of the agreement executed in 2011.
As regards to cause of action,
My lord, my cause of action was not dealt by the learned trial court. But however, my submissions were recorded. My lord, it is on the very first page of the order itself. If I may place, my lord, it starts from the fourth paragraph. Learned advocate for the defendant, which is myself, by filing this petition, submitted that from the averment of the plaintiff, it is clear that the plaintiff filed the suit with sole intention of harassing the defendants. He further submitted that defendants acquired the right, title, and interest in the suit property through an agreement to sell dated 29th of May 2011 between one Mr. Srinath Rai and Srimati Aarti Rai, who were the owners of the suit property at the time, and that said agreement is a concluded contract and same is legally enforceable and binding upon all the parties to the contract. He further contended that under the provision of Indian Contract Act 1872, a concluded contract cannot be cancelled unilaterally by any party to the contract. He further submitted that agreement to sell dated 29th May 2011 was legally enforced and executed through Honorable Arbitration Tribunal Award dated 30th of July 2014, and subsequently sale conveyance deed dated 5th of May 2017 was executed through an execution decree passed by the learned Additional District Judge Alipur. And accordingly, as a matter of ownership of the suit property had already been decided by the Honorable Arbitration Tribunal in favor of the defendants, therefore the present suit is barred under Section 11 of the CPC, Principles of Res Judicata, and the plaintiff is liable to be rejected in accordance with provisions of Order 7/11, Subclause D of CPC 190. He further contended that the plaintiff had no cause of action and plaintiff had completely failed to establish a cause of action for filing the suit, and cause of action whereas devoid of any merit. Therefore, the plaintiff is liable to be rejected in accordance with the provision of Order 7/11. A. Learned advocate for the defendant further submitted, this is a very important paragraph, that defendant had legally acquired the decree passed by a superior court than this court, hence the plaintiff is liable to be rejected in accordance with provision of Order 7/11D and prayed for rejection of the plaint under Order 7/11 CPC and Principle of Res Judicata, Section 11 CPC.
anything more to be submitted?
My lord, I need to place, my lord, one judgment, my lord. Copy in each. My lord, the citation is 2025 volume 10 SCC 279. My lord. If my lord kindly comes to paragraph C, my lord. My lord, pascentum F. I'm reading, my lord, from 25 onwards, 6 subclause 25. On a perusal of the above authorities, the guiding principle for deciding.
Which paragraph you are placing? Which
My lord,
paragraph?
625, my lord. Pascentum F, just above pascentum F.
Pascentum
F. Between E and F, my lord.
25.1.
My lord, from 25 onwards.
Okay.
On a perusal of the above authorities, the guiding principles for the deciding an application under Order 7/11 can be summarized as follows. To reject a plaint on the ground that the suit is barred by any law, only the averments in the plaint will have to be referred to. So, my lord, in the plaint, it has been referred because they have the knowledge that there was a deed of conveyance which was executed by the dint of an award passed by the arbitral tribunal, which was further culminating into the execution proceedings. And I have the possession of the property. Now 25.2. The defense made by the defendant in the suit must not be considered while deciding the merits of the application. My lord, I am not relying on my written statement. 25.3. To determine whether a suit is barred by res judicata, it is necessary that the previous suit is decided. So, my lord, the issue is already decided in the arbitration proceedings. My lord, subclause 2, the issues in the subsequent suit were directly and substantially an issue in the former suit. My lord, even this principle applies to my case. 25(3).
Page 283. That page was not
But
there.
I had handed over the wrong judgment.
Page 283. Yes.
Now, 25.3 subclause 3, my lord, the former
Yes, the
suit
former suit was between the same parties or
and those whom the claim litigated
the
at the
criteria of res judicata have been placed.
My lord.
Yes.
So, my lord, I was saying that my order 7, rule 11 ought to be allowed.
Anything more?
This is my submission, sir.
My lord, my lord, my lord. Submitted before your lordships that my suit is brought by res judicata as well as cause of action. No, there is no cause of action. Your lordships kindly see, my lord, they have, my lord, annexed the plaint of the, my lord, title suit, my lord. My lord, if your lordship, page 25 of the application, revisional application, my lord.
Yes.
My lord, paragraph 15, that the cause of action of this suit arose on 23rd October 2013. Thereafter, on several dates, specifically on 18/6/2019, when the plaintiff came to know about the execution of the deed of conveyance dated March 2017, and lastly on 14/9/2019, when the order was passed by the Municipal Commissioner KMC by cancelling the mutation of the defendants, and same is counting from day to day as scheduled a premises.
They are relying upon the issue of res judicata.
Your lordships kindly see, my sale deed was executed on my lord 23rd of October 2013. Much prior to my lord agreement of sale.
Between them.
Now, their sale deed was 5th of May 2017. My sale deed was executed on my lord 23rd of October 2013. My lord, now my learned friend which has been, my lord, submitted before your lordships, my lord, is beyond the plains. My lord, if it is beyond the plane, how it can become within the purview of Order 7, Rule 11 of the Code of Civil Procedure, my lord? It cannot be. My lord, your lordships kindly see the impugned order of the, my lord, learned trial judge, my lord, page, my lord, 52.
Consider
52, my lord, last paragraph. I am reading, my lord. Consider the submission of both sides, peruse the documents available on record. I find that the settled principle of law is the court is to limit its purview under Order 7, Rule 11 CPC only to the facts disclosed in the plaint.
beyond the plan.
This is they have been what they have been stated. This is beyond the plaint, not within my plaint. Second, not only that, my lord, the arbitral proceedings, which is my learned friend has referred, my lord, there I was not a party at all. How it can be but by this judicator? My lord, I am putting to question myself. My sale date is prior. It was
both of you are submitting.
Yes, my lord.
I am waiting for that moment. Both of you are submitting without any document in support of your contention. Only submitting.
Well,
the court won't go through the documents.
My
The
lord,
documents are not required.
My lord, it is
In support of your contention, both of you, not learned counsel, not only you. He has also submitted. He has completed his submission without any document in support of his contention.
My lord, this is the finding of the learned court, my lord. Kindly see, my lord. Kindly see how the learned court has dealt with the my lord, questions.
Learned senior counsel,
Yes, my lord.
to consider whether the impugned order is correct or not, you will have to come with the documents in support of your contention. Neither the petitioner nor you.
My lord, I have
Nobody is-
sealed it, my lord.
That you have with you. Have
document
you produced anything in support of your contention?
My
Neither
lord,
the petitioner has produced anything.
yes, my lord, I have, my lord, sealed it perhaps. My lord, kindly, my lord.
Shall I
The
come
plaint
up with
have
the
you- In the plaint, have you mentioned? Wherein have you mentioned?
My lord, plainly, my lord, I have stated, my lord, that my sale deed was in 23rd of October to 2013. In my
23rd of October 2013.
13.
Their sale date was 5th of May 2017.
Learned counsel, both of you can speak.
No,
No,
sorry.
my lord.
If you can speak, then
My
you,
lord, he is assisting me.
No, sorry.
that assistance should be in the chamber of your chamber,
Yes,
not
grateful,
in the
grateful.
courtroom.
My lord, this is my sale deed, my lord. I have
Sale date কোথায় আছে? 23 ইভেন্ট non-judicial
List of documents. In the list of documents,
list of
where is the
documents.
annexure?
Link-
That annexure?
লিঙ্কটা খোলো
it's a
লিঙ্কটা দেখছো
Annexure A.
অ্যানেক্সের লিঙ্কটা খোলো লিঙ্কটা খুলবে
Learned counsel,
My lord,
where
it
are
is
those
not-
annexures?
এতে অ্যানেক্সটা
not
আছে
there
না
because the plaint
So,
was served without annexure.
খুলবে
you have-
লিঙ্কটাতে অ্যানেক্সের আছে
You have filed the copy of the plaint without annexure.
My lord,
Well done.
may I come up with a supplement?
No, no,
এটা ভুলে যেত
my lord, page
you
28.
cannot.
page 28 list of
When
documents
the annexures are a part of the plaint, you shall have to, you should have been filing those annexures.
My lord, in my plaint, my lord, I have, my lord, kindly see, my lord, page 28. List of documents I have filed, my lord.
Yes, gone through the list of documents.
Grateful, my lord.
Must have been furnished to them. Being annexure A, annexure B, annexure C, annexure D, annexure E, annexure EF, annexure G.
Lord,
Where are those annexures in the, along with the
my lord,
plaint?
in fact, the plaint of what we have received was also without annexures.
And on the basis of that, you have filed the order 7 rule 11 without going through the annexures. Then, but this court won't do that.
My lord, I can obtain all certified copies and I come up with a supplementary affidavit, my lord directs me. I apologize for my mistake, my lord.
Civil revision 2026. Through the supplementary affidavit, you will have to provide all the annexures. Learned
Lord, I'll
counsel.
do that. I'll do.
You have obtained the certified copies.
I'll obtain the certified copy.
You will obtain.
division bench
Without obtaining those, you have filed the application under order 7 rule 11.
My lord, the
It
documents
is
of
up to you. Nil.
My lord, in this connection, my lord, I wish to, my lord, refer two judgments, my lord. One of our
division bench
DC, court, my lord, division bench judgment, where, my lord, paragraph 10 of the
The learned counsel representing the petitioner seeks an accommodation to
accommodation.
file supplementary affidavit annexing the annexures annexed to the plaint. When can you file?
my lord, within 10 days, my lord.
Hmm?
Within 10 days, my lord.
And seeks an accommodation for 10 days. Full stop. Let the matter appear on,
once copy দেবে তো?
let the matter appear on 22nd of September.
With an advance copy to me, my lord.
Then the petitioner, the petitioners,
Petitioner.
the petitioner is directed to provide an advance copy of the supplementary affidavit to the learned counsel representing the opposite parties.
Opposite parties.
Opposite parties. Full stop. Provide the documents
my lord.
in support of your contention. Without that,
22nd September.
22nd September. If the facts are not supported, the judgment will come later on.
My lord, actually, even I was also engaged in this matter on a very later stage.
Next.
Grateful.
27 and 32 may be taken up together, my lord. More or less identical set of facts. Are we placing 27 first, my lord?
Let us take up 27 first.
The petition is a plaintiff in a suit for declaration of his tenancy rights and injunction, consequential release, my lord. The order impugned is an order by which, my lord, an application for addition of party has been allowed at the instance of a third party. So, my lord, that is the order, my lord, impugned. Third party makes an application on Order 1, Rule 10.
What is the status of that third party?
My lord, he says he is an agreement for sale holder. He says he is an agreement for sale holder, my lord. And the agreement for sale that he says was of the year 2010. He says he's been put in possession by virtue thereof. Now, my lord, one issue would arise is this thing, my lord, whether in 2010 a non-registered agreement for sale could, my lord, provide a litigant or a suitor, my lord, to approach the court, because in 2001 onwards, my lord, the amendment to section 17 of the Registration Act says that agreement has to be registered. So, my lord, whether he has any locus to intervene, number one. Number two, he says he's an independent right. So, if he's an independent right, my lord, he probably cannot meddle into in my suit. If at all a decree is passed in my favor and I go to execute that, he might, my lord, upon advice, file an application under Order 21 and espouse his cause. So, for the present, my lord, I guess, my lord, that he doesn't have any locus, not any right, my lord, to implead himself in my suit. But this is some substance of, my lord, the application. My lord, kindly sees the plaint, which is at page 19.
What has been the objection to the Order 1, Rule 10(2) application?
My lord, the order.
Landlord. Has
My lord,
the landlord filed any objection to the Order 1?
no, my lord, the landlord is not there, my lord. This the objection is by at my instance, because, my lord, the landlord has not filed an objection.
And landlord has not filed.
So, my lord, but the most important thing, my lord, is the impugned order. Now, if my lord kindly sees the impugned order, kindly sees, my the impugned order is dated 14th of 11, 2025.
Yes, 14th of 11, 2025.
Yes, my lord. Today's passing order, plaintiff appellant duly represented by the learned advocates. It is mentioned that the record has been proceeded ex parte against the sole defendant, Suman Singh. Suman, my lord, the sole defendant, who is the landowner, my lord, the suit is running ex parte against him. Record is taken up for passing order. Learned advocates for the parties in full considered peruse the entire records. On such perusal, it has transpired that the applicant, such and such, has filed this instant petition seeking for impleadment as a party to this suit under the provisions of Order 1, Rule 10, on the ground that he is in peaceful possession of the suit property of the plaintiff, being delivered by the defendant of the suit in terms of an agreement for sale executed by and between him and the present defendant.
At what stage Order 1, Rule 10(2) application was made?
My lord, I believe this was at the stage of arguments, because, my lord, kindly sees, be it mentioned, the record has been proceeded ex parte against the sole defendant. That's what the learned judge in the court below holds.
Maybe,
my lord. So, my lord,
cannot be also.
It's proceeding ex parte.
Ex
That's
parte.
certain.
Ex parte.
Ex parte. Now, my lord, most importantly, my lord, kindly sees, it says following the said.
This paragraph, it also reveals from the written objection filed from the side of the plaintiff that several suits and counter suits have been filed by the parties against each other in respect of this property as well as other properties with severe allegation of forged documents.
I'll indicate, my lord. Now, my lord, let me indicate. My lord, now comes to my plaint.
Page?
My lord, the plaint is at page 19, my lord. The reliefs are at page 25.
Yes.
Let's see, the relief as I seek in the plaint is at page 25. This would be after paragraph 15. The plaintiff therefore prays a decree declaring that in terms of the tenancy agreement dated such and such executed by and between the parties to the suit, the plaintiff is a rightful tenant of the property mentioned in the schedule. So, it's a declaration of a tenancy right. In such a suit, I take out an injunction application which appears at page 28 and the prayer is at page 32. It says, please to restrain the defendant by an order of temporary injunction from disturbing, obstructing the plaintiff's possession. So this was my application. Now an order of status quo was passed, which would appear at page 36.
At the time of hearing of the temporary injunction, whatever might be, ad interim temporary or temporary injunction, what documents did you produce in support of your contention?
Documents that was produced would be my rent receipts and the agreement for sale, or the agreement of tenancy.
From any order, will that reflect?
Millard would kindly see page 35. Peruse the plaint as well as the documents annexed thereto. So, documents were produced, and good, bad, indifferent parties were directed to maintain status quo.
No.
Parties
as regards to possession, what did you produce?
I'll
at
just
that
take
relevant point
I'll
of
I'll
time?
just take a moment of my lord. I'll just take a moment of my lord. I'll just- I'll just take a moment of my lord.
Who is her senior? Since morning she is sneezing and she is to be looked after. Take care, learned counsel.
Mulot, I'll be very frank and candid. Mulot, the injunction application does not mention any documents.
Only documents.
Mulot, I would take it as it is, Mulot. I cannot improve this. But be that as it may, Mulot, kindly takes up page 35. This is an order of status quo.
Yes, a status quo.
Passed, Mulot. Now, this order was made absolute at page 37, Mulot.
Yes.
38, Mulot, kindly takes up page 38. This would be the third paragraph. On such observation, let the order dated such and such be recalled. Order of ad interim passed on 26/11 and extended time be made absolute. So, not absolute. Then, Millard, page 39 is an order passed pursuant to an application made by an instance, Millard. Kindly sees page 39, last paragraph. I have considered the contents of the petition from where it appears that there has breach of peace within the suit property and police case has started and later converted into a GR. In another occasion, while passing such order for implementation of injunction order, this court already recorded a strong displeasure about the manner in which the law enforcing agency of this area is trying to avoid their duty. It is unfortunate to remind the police has a duty to maintain law and order, and as the machinery to maintain of law, police has a solemn duty to take appropriate steps so that the order passed by this court be respected by every common man. Otherwise, system of rule of law cannot be protected. Then, when a local PS again requested to see law and order situation is maintained in the disputed property.
Copy of the revision application has not yet
It's
been
coming for
served.
first time.
The learned counsel representing the petitioner submits that the impugned order allowing the application of a third party to be added as a party in the present list is not in accordance with law. Full stop. being aggrieved by and dissatisfied with the impugned order, the petitioner plaintiff has preferred the revisional application, full stop. On perusal of the documents on record and the submission of the learned counsel, it transpires that there's an arguable case as to whether the prayer allowing the addition of party was in accordance with law or not. The present revisional application will be heard on this issue. Full stop. Let a copy of the revisional application be served upon the opposite party. Opposite parties.
Opposite parties, my primary grievance would be against the opposite party number 2, whose application.
Let it be served upon the
both.
opposite parties. Opposite parties. The petitioner is further directed to file an affidavit of service in this regard on the returnable date. Let the matter appear.
Any day,
Let the matter appear on September 23rd September.
Till that time, let the further progress of the suit be stated. Suit is my instance, or let the operation of impugned order be stated. It's at my instance. Suit is at my instance, or then permits me to seek an adjournment in the court below if the matter is taken up.
Learned counsel.
Nowadays,
then you can place it before the trial.
Nowadays, my lord realizes now after there's a direction from this court saying that till there's no stay order of stay passed, the courts are free to proceed. I understand, but one line.
When is the next date?
I leave it to you, Lordship. I leave it to you, Lordship.
This court will pass an order of stay if it finds that you will be prejudiced.
I'm so grateful. 32 would be on similar set of facts. Similar set of facts.
When called between the same parties.
Well, only one defendant is changed, but the person at whose instance the order 1 rule 10 has been allowed, the same person's order 1 rule 10 in 32.
So 2 shop rooms in the same
yes,
properties.
Yes.
Same.
Yes.
Cases.
Yes, my lord.
Let that be mentioned when it is called.
I am grateful.
Next.
Item number 28.
28, I am for the petitioner kindly accommodate me for this week, my lord. I have served pursuant to your lordship's direction, my lord. I have served. They are appearing. There is no problem. Service is complete. Last occasion, while admitting the motion, my lord was pleased to direct me to serve. I have served.
What is the matter involved?
The matter, my lord, this eviction suit. After the degree pass, we are the, my lord, tenant judgment debtor. After the degree is passed, degree was put in execution. Suddenly, my lord, the plaintiff landlord, my lord, filed one petition praying for, my lord, amendment of the, my lord, the decretal suit property before the original court. Schedule. That was allowed.
That was allowed.
Challenging that, we have preferred this division.
Challenging that.
Challenging that. Assailing that, my learned senior friend has come.
What was left behind? What was left?
It was an arithmetical. It was an arithmetical error. The schedule premises. I tell your lordship, the schedule.
Let them submit.
Your lordship, some difficulty.
My lord, I will be also making a prayer, my lord, for adjournment, my lord. Let us complete it, my lord.
14, my lord. Your lordship will be coming back on 14.
My lord, difficulties is, but I am though. It kindly accommodates only for this day, my lord, because.
Is there any difficulty as regards to tangible instruction?
And the opposite party number 1 is also not here. My lord, I am the opposite party number 2, who is the defendant, original defendant. The opposite party number 1 is the plaintiff. He has not been there. My lord, without in his absence, my lord, this matter cannot be decided.
Who is the landlord? You are not the landlord.
No, I am the tenant. I am the tenant. I tell your lordship what has happened.
He is claiming to be the tenant.
But I am the defendant. I am the original defendant. I tell you, lordship. I am the original defendant. Plaintiff brought a suit for eviction. Compromise decree was we got a compromise decree. between me and the landlord.
Hmm.
Thereafter, my lord, the decree was not honored by me, but still there are occupants therein. My learned senior friend's client is with the occupants, those who are staying in the premises. He has taken out an application under Order 21, Rule 97 of the Code of Civil Procedure. Now, I happen to be that original tenant with whom there was a compromise decree. Now,
Subsequently, what occurred?
subsequently, my lord, since the decree could not be executed due to an arithmetical error.
What is the arithmetical error?
Arithmetical error, my lord, the premises number, the boundary, my lord, there, my lord, certain errors are there.
No. Boundaries butted and bounded by, that is something else. Arithmetical error is something
Total
else.
boundary change.
That is
Arithmetical error means maybe 53 instead of 53, 54 has been mentioned. Either that, and if you say it is butted and bounded is not mentioned.
I have the schedule of the premises, my lord, I have the schedule. Suppose there is 44, it should be read as 24. That is the arithmetical error. That's why, my lord, landlord has prepared an application for compromise. For amendment of the schedule. My lord, we supported it. Now,
What were you doing at the time of filing the examination in chief? At that time, you had not gone through the plaint.
that has not been, what is there over there? But that has happened now without the landlord, my lord.
The landlord I have served.
Landlord council, the landlord is required. Landlord is
I have
also-
served.
You are for the landlord.
I am for the landlord. I am opposite party number 1. Today I am only praying for not today. That's it.
Why?
Because my senior Kosik Bhattu is out of station just now. So
I am filing the affidavit of service.
Affidavit of service has been filed on behalf of the petitioner. Full stop. Both the opposite parties are being represented. Full stop. The learned paragraph, learned counsels representing the petitioners and the opposite parties seeks an accommodation. Let full stop, on consent of all the sides, let the matter appear on
14, subject to your lordship. ও তো পুজো মনে করেন 16 তারিখে লড় করে দিন আছে অত ওখানে যে ঝগড়া শুরু করে না
Ganesh Chaturthi.
on that day we celebrate in Bharat room number 2 we celebrate that puja we will be
On
busy
15th, my lord, subject to
15th,
the secretary of that.
15th. Let the matter appear on 15th.
great.
Next.
Item number 29, I am appearing for the petitioner, and I am praying for an accommodation because my lord, the matter has been settled.
Let it be called first.
I am sorry, my lord. I am sorry.
কি জিনিস না খুঁজে পাচ্ছি না কোনো রিজন নেই ওটা কোনো জানা বার করুন নাহলে আজকে শোকজ করবো সকল কি পরিচয় হবে খুঁজে পাচ্ছি না ওটা কোনো কারণ না ওদের পিয়ন কোথায় বার করুন ইয়েস 29 ডাকুন
Item number 29.
My lord, I am appearing for the petitioner. My lord, here the petitioner and the opposite parties have signed the MOU for settling the matter. My lord, in terms of the MOU, the opposite parties have agreed to withdraw the case before the consumer forum, from which, my lord, this revision has been preferred. Next date is, my lord, on 1st September. So I was praying, my lord, for a accommodation till 1st September, because if they withdraw it, my lord, I'll come and withdraw this revisional application. It will not survive, my lord.
Not today.
I'm grateful, my lord.
Next, no order is being passed. Not today.
I'm
Next.
deeply obliged, my lord.
Next.
Item number
No order,
30.
Learned Council, no order is being passed. $30.
No.
করতে পার করে আজকে দেখাবেন বলে দিচ্ছি 30 none is representing either either for the petitioners or for the opposite parties. This is the second day during which none is representing. In such circumstance, the revision application is dismissed for default. Two, three, four. Next, dismiss for default. Next.
Item number 31.
Yes, madam. 31, madam, appearing for the plaintiff decree holder, madam, in this matter, madam, petitioner. This is suit was filed, madam, in respect to, madam, I have prayed for preemption, basically a preemption matter, madam, under
Section 8.
not section 8, madam. This is under madam, section 22 of the Hindu Succession Act, read with section 4 of Partition Act. Now, madam, as per the trust deed, madam, separate positions were allotted to the specific, all the allottees. Now, I have filed a suit, I got a decree. Appeal court, they have traveled. Appeal court also affirmed that decree, and ultimately, High Court have dismissed their appeal. Now, the only point is that, my lord, if your lordship kindly takes, yes, if your lordship kindly takes page 63. This is the decree which was passed in the suit. Lordship will kindly see the order that the suit be and the same is decreed on contest against the defendants. The plaintiff do get a decree of declaration that the plaintiff has preferential right to purchase the suit property at a reasonable price, and the defendant number 1 to 10 have no right to sell, transfer, assign, or part with the possession of their allotments to any third party without giving offer to the plaintiffs. That the transactions made by defendant number 1 to 10 in favor of defendant number 11 is declared as void if any transaction made between the defendant number 1 to 11 and the defendant number 11. The parties to the suit are hereby directed to make reasonable valuation about the suit property, and plaintiff will purchase the property after making payment to the other party, and possession will be delivered thereafter and after execution of deed amicably, failing which the plaintiff has liberty to put the decree into execution. So, there was a direction wherein in 2014, my suit was decreed in the year 2014. Now, a reasonable valuation has to be assessed. Now, in the meantime, if your lordship kindly takes page 65, they went to the appeal court. Now, in the appeal court, this appeal was decreed on. Yes.
Decreed or dismissed?
That their appeal was dismissed. Sorry. Their appeal was dismissed. Lordship will kindly takes page 65. This appeal, the order of judgment decree was passed on 28th March 2018. Now, I'll come just to the relevant portion. So, lordship sees, my lord, at page 81. Second paragraph, my lord.
81, yes. In
Yes.
view of the.
Yes. So, this is a relevant part. In view of there will be nothing wrong on the part of the learned judge to come into such conversation regarding fate of learned advocates notice so and so. Now, here also fate last 3 lines. He has preferential right to purchase the suit property at a reasonable price. Here also it is stated reasonable price. Now, my lord, thereafter, my lord, they went to High Court. My lord, will kindly takes at page 84. None appears for the appellant even at the second call. No accommodation paid for, the appeal is dismissed for default. So now after that, they have not taken any steps. Now, my lord, in the year 2018, I have filed an application at page 85 before the executing court. Yes. Now, it has been filed on 1st August 2018. Execution case was 35 of 2018. That is at page 85. Now, lordship will kindly seize, my lord, paragraph 3. That is at page 86. That the plaintiff, as per compliance of the said judgment and decree, wrote a letter to on 25th March 2014 through learned advocate Somendranath Nandi to the defendants with an offer to purchase the suit property, that is 4A Indro Roy Road, Police Station, Bhawanipur, Kolkata 25, at a total consideration of 25,50,000, and to intimate the plaintiff within 7 days from the date of the receipt regarding their intention. In spite of the receipt of the letter, the defendant did not reply and or intimate anything to the plaintiff as yet, or not they raise any objection. Be it mentioned that said offer of 25,50,000 was the purchase price of the premises by the defendant number 11, Bishorai, from defendant number 1 to 10. So, my lord, as per my bona fide, my lord, I have tried to, my lord, write a letter through my advocate. The see 25,50,000 you have paid for the purchase, my lord. I am ready to pay that amount as per the decree of the court, my lord, which says reasonable price has to be paid. Now, your lordship will kindly seize, my lord. Well, after, my lord,
reasonable price means what is assessed by the
now, my lord,
office of registration.
yes. Now, my lord, I'll take a point, my lord. Well, I got a decree in 2014. Now, my lord, they went to the appeal court and they have, my lord, kept this matter pending since 2026 is pending. Now, my lord, for that reason, my lord, I cannot be liable to pay the, my lord, the whatever the, my lord, the upliftment in the property prices. That I cannot be, my lord, liable to pay. My lord, what I am trying to say before your lordship, my lord, as there was a, yes, my lord,
Authority.
yes.
Not now.
Now, my lord, today, my lord, lordship will see, visualize the situation. Today, my lord, I am going to purchase my co-sharer's property because I am the co-sharer of the property. It is my predecessor's property.
Period, it has enhanced.
Yes. Now, my lord, as per reasonable value,
Here the enhanced rate. That is the question.
whether I will bear or not, because my lord, there is the decree is passed in 2014. Well, I have made an application in executing court before in the 2018.
Not served as yet.
Not served, man. Well, because there is no caveat, man, I'll serve it. Then
and come with authorities. In
well,
support
then
of
also, my lord, lordship will kindly records that, my lord. My lord, for an appeal which has been filed by them, ultimately that appeal was dismissed. It is not a case that they have succeeded in the appeal. In that situation, my lord, where a co-owner will be benefited or my lord, he will be defeated. Because otherwise my decree will go infructuous.
The learned counsel representing the petitioner submits that wide judgment dated initially judgment was passed on
yes
in
2014
on 30th of January 2014. The learned trial judge was pleased to declare that the plaintiff, that the petitioner plaintiff has preferential right to purchase the suit property at a reasonable price. Full stop. Against the said order, against the said judgment, the opposite party or parties?
Mala opposite parties.
Opposite parties.
But herein Mala only there was only one appellant. In page 65, Mala, I could find only Shomunath Roy was the appellant.
Then might have been
the pro forma. Yes, yes.
Opposite parties preferred an appeal, and the said appeal was dismissed. Subsequently,
yes,
they have preferred a special leave application before the
no before the Mala, this is before the High Court. Mala SAT, so Mala their appeal was not admitted.
Second appeal was not admitted.
Not admitted.
Subsequent to the rejection, to the dismissal of the first appeal, subsequent to the dismissal of the first appeal, the opposite parties preferred a second appeal before the Honorable Court, which was ultimately not admitted.
And dismissed on 16 January 2022, man.
And dismissed.
Right. 2020, man. That's all. 2020.
Dismissed on
16 January 2020.
16th January 2020.
Yes.
Full stop.
My application was filed in 2018.
He has further submitted that in the interregnum period during the year 2018, the petitioner had prayed for through the said application. What had you prayed?
Yes, mala execution, mala that I'll pay
for execution of the decree passed by the learned trial judge. Full stop. Paragraph. From the contention of the learned counsel representing the petitioner, it transpires that the moot point is that as to whether the petitioner, being a decree holder, passed by a judgment in the year 2014, will bear the enhanced rate of the property while purchasing now, in spite of being a co-sharer of the said entire suit property. Full stop. The revisional application is admitted and shall be heard on this issue. Full stop. Paragraph. As a copy of the revisional application has not been served upon the opposite parties, let the copy of the revisional application be served upon the opposite parties, and the petitioner is directed to file an affidavit of service in this regard on the returnable date. Paragraph. Let the matter appear on
2 weeks, because all are in Kolkata only.
let the matter appear on 17th.
Yes, yes.
17th of September.
Return.
17th of September.
Grateful.
Next. এখানে আছে লিস্টে লিস্টে তো আছে কি করে ভুলবো আপনারা না দিলে কি করে আসে নেক্সট
Number 32.
Right, yes. No, here is a case where it's a suit for declaration of title. So I have a conveyance in my favor. Defendants are 1 and 2. I challenge, I say that I am the owner of the property against defendant 1 and 2. Again, in the same suit, I get an order of injunction. I am dispossessed. Pursuant whereto have sought to amend the plaint for recovery possession. Now this gentleman.
Oh, herein you are admitting that you have been dispossessed.
Yes.
But in that one you are.
That really makes not much of a difference. But the issue is, this gentleman is an interloper. He is neither the defendant number 1 nor the defendant number 2. I say I have been dispossessed by the defendant number 2, and in view thereof, order 39 rule 2A application is pending. Be that as it may, here is the interloper who comes, makes an application on order 1 rule 10 on the basis of an agreement for sale. Again, that would be paragraph page 50 is his application.
Same issue.
Same issue. 2010.
Item number 25.
27.
27. 27 was in accordance with law or not? Or not? Oh yeah, same.
Same date, both the dates are after 23rd. That I've inquired.
ওই যা ডেট হয়েছে আগের দিন আগের দিন 27 সেম ডেট হবে
23rd of September.
Same date.
I'm so grateful. So grateful.
But some clear.
But this copy is also not very good. So I'll get it typed and give it tomorrow morning. I'll get it freshly typed and give it tomorrow morning.
Do not miss that.
No, I'll give the typed copy along with this.
Yes,
copy.
this. Next.
Item number 33.
Next. 33 তো লেগে আছে this one will have to be dismissed, so let us not take up.
No, item number 37, we have both sides. This is that matter where there are two civil revision applications. One was being taken up by court number 2 and one was being taken up by your lordship. Court number 2 was pleased to release the matter because I believe court number 2 was taking it up from Delhi. So my lord has to come back and then sign the order and then get it assigned. This this has been, the order has been passed. The order has not yet been signed. What the difficulty is that yesterday I was released from the hospital. But today I have come, but I won't be able to come for the next week. I'm not feeling well.
Let the
it
matter
be
appear
kept a week
tomorrow.
after.
Week after.
By that time, that file will also come down.
My lord, this is my revisional application.
Yes.
Against an earlier order, they have preferred a revisional application, which was.
No, is there a disparity between
There is no
There
disparity.
is no disparity. My presence only, my lord. On Monday, that matter has been released. They have mentioned the matter and got released from that place.
In the internal period, let the developments take place.
Yes. Keeps it on the Monday week.
শুনুন এটাকে
Monday week.
এটাকে না এটা
আমি 7 দিনের
on or after 14 because not prior to that কি বলে এটা ওই আইটেম নাম্বার 37 ওটা কালকে দেব। হ্যাঁ বলে দিচ্ছি
37. I believe there will be a requirement of a one-line order, my lord. This matter is there in the list. The matter suddenly goes out of the. Both sides are present. The matter can be called on.
Okay. But this will appear on 14th.
After 14.
Lordship, if you're with your lordship's permission, lordship, I'm there for item number 35 for the petitioner. The matter has become infructuous, lordship. Yes, your lordship. Your lordship, it was the application was mainly made regarding a puja that was supposed to be held on 29 January, and there was an injunction in the property. Thereafter, the puja has already happened, and the injunction is also going on. So the application does not remain, your lord. 35, your lordship.
Before my lord.
Much obliged, your lordship.
Before my lord rises, my lord.
Much
with regard to item number 39.
Okay. Much obliged.
39, with regard to item number 39, the plaintiff is the petitioner, the landlord is the petitioner. If it's taken up tomorrow, and with regard to item number 64 of today's list, my lord would recall that the matter which was prolonged eviction suit, which was from 2005, my lord was pleased to take up the matter last week, and my lord was pleased to direct the petitioner to file a supplementary affidavit to bring on record the prescription. My lord recalls that order. If my lord, some preference is given to item number 64. 31st is the next date before the trial court, before the small causes court, where a suit for eviction was filed in the year 2005. In 2022, the suit got dismissed. 2014, the suit got dismissed at the evidence stage. But that on since there's no stay, the whole difficulty is a miscase was for restoration. Order 9, Rule 9 petition was filed. Evidence was adducing evidence was going on. Evidence was going on. My lord, medical prescription, doctor's certificate was exhibited. My lord, that was marked for exhibit. Today, the trial court is asking the doctor to be on box to give adduce evidence. My lord was of the view that since that was not on record with the revisional application, to file a supplementary affidavit to see the veracity of the doctor's certificate and the medical certificate issued by the doctor, my lord. So I had filed it. If my lord, until and unless it is taken up. Yes, my lord has passed an order. The whole difficulty, my lord, my lord, the court. That is the thing, my lord. But the trial court is of the rigorous view that the doctor has to be present before the trial, before the court. I'm grateful, my lord. And if time permits, it can be taken up tomorrow.